C'est formidable.
Fantastic. You're all very silent, but I didn't receive the go to begin because we are also online. Yes, I have got the go now. Hello, everyone. First of all, welcome to Paris, to those who were able to come from their respective countries. Welcome to those who are also remote. We are very happy to be able to speak with you today and tomorrow to talk about fighting against discriminations. And we are happy to have here in person and virtually our spokespeople who work on discriminations as well, our national partners, institutionals, but also from associations with whom we exchange often, professionals in law, researchers. We see a few of them, but agents and delegates who defend rights. I'm very happy that we are co-organizing this with Equinet, our European network of equality bodies, within the framework and with the support of the French Presidency of the European Union. So just for you to know, during this French Presidency, I co-organized a conference in Strasbourg, end of April, with Emily O'Reilly, the European Ombudsman, and my fellow ombudsmen, some of whom are here today, because just as me, they have several competences. We have discussed of the role of the ombudsman in the face of three challenges, crisis situations and particular pandemics, the dematerialization of public services, the implementation of the temporary protection set up by the European Union for Ukrainian refugees fleeing the war, without forgetting the protection of the rights and freedoms of all other refugees. We cannot deal with these issues efficiently and effectively if we remain isolated in our own preoccupations. To make progress on the protection of fundamental rights and freedoms enshrined in our Charter of Fundamental Rights of the EU, we must work together with our partners and in close collaboration with the institutions of the EU. I'm very impressed, since I started my work a few years ago, to see to what extent these exchanges really feed us. And this is why we wanted, with Laurence Bon, president of Equinet, to devote a second event to the fight against discrimination in Europe and to this challenge that must be taken up by the bodies in charge of equal treatment. Laurence could not be present today. She will be with us tomorrow, but we have Anne Gaspard and Tamas Kadar, co-directors of Equinet, who represent the network this afternoon. They're here with us in the audience. Our event will take place over 2 half days. This afternoon, I wanted us to discuss the role and effectiveness of the equality bodies before the courts. 2 draft directives are being prepared by the European Commission to define standards to reinforce the action of these bodies. I think it is important that these standards provide, among other things, for progress in terms of investigations and interventions before the courts. The examples that will be presented this afternoon will underline the importance of this capacity for action by our institutions. Claire Hasenfratz, who is very involved in this project at the European Commission, will share with us valuable information on these upcoming texts at the end of the second session. Thank you for being here. Tomorrow morning, we will take stock on the European text existing or under discussion in the field of equality between women and men, as proposed by Laurence, with the Equinet Secretariat, who I would like to thank for their efficient mobilization. The directives that will be discussed, as you will see, seem to foresee provisions that would give us new missions and responsibilities. I will have time to come back on this topic tomorrow morning. A little more than 20 years ago, the European directives known as the Race Directive and the Employment Directive created tremendous momentum in the field of non-discrimination law. They also allowed the creation of dedicated organizations in charge of promoting this new legal framework to all actors, public and private, but also to the judicial institution. And in 2000, unlike in Belgium, for example, or in the United Kingdom, there was no equal treatment body in France, as in many other member states. The HALD, High Authority for the Fight Against Discrimination and for Equality, created in 2004, and then the Human Rights Defender, who took over this mission in 2011, were created by Directive 2000/43. This is essential because with the ALD and then the Defender of War, it had a power to investigate and to intervene before of the national jurisdictions and European ones. It is absolutely crucial because the protection against discrimination cannot be effective if there is no access to judges and the court, and the ability to present its cause is ensured. In this regard, proof is essential. It responds partly, not all completely, to this establishing proof and inequality of weapon between the victim and the administration or company. But this mechanism is insufficient. Indeed, inequality of arms persists, and if we can action this mechanism, to do so, we need upstream elements, all these indicators. This power of investigation are sometimes better able to gather these elements than lawyers or associations supporting claimants, even though their role is otherwise absolutely essential and complementary. I will say a word about this later. In a second step, we can intervene before the competent courts if the claimant has brought the matter before them in parallel. Is it necessary? I think other avenues can be very useful. The remarkable work of our counterparts who do not have this power shows this. In fact, for the vast majority of the cases that we receive, the mediation or resolution, amicable resolution, is sufficient to bring about a solution, and the victim wants that very much so. Nevertheless, it seems crucial to me to participate as an expert, but also as an observer and watchdog in the judge's decision, because litigation is one of the fundamental levers of action for clarifying or censoring the law and practices that are discriminatory. The first roundtable will deal with this issue and will be moderated by Isabelle Rorive, who has been training our lawyers for many years in the developments of European law. I would like to thank her very much for being with us today. Our first session aims to report on the experiences of our counterparts who have brought cases before national or European courts as amicus curiae or civil parties. We will see what they contributed to, their effects on non-discrimination law and support for victims. I am very pleased that we have the testimony at the beginning of the session of Fida Marouf. At the beginning of the session, he will talk about his experience in the Irish courts and in particular with the support of the Irish authority in a case of discrimination based on origin in relation to banks. Stephen Collins, a lawyer with this Irish Commission, will present the experience of his authority in this and other cases as well. Karine Abstrand-Oxhamre, sorry if I'm not pronouncing well, head of litigation, Equal Treatment Ombud, and Patrick Charlier, co-director of UNIA, will in turn present their powers and practices in strategic litigation, both nationally, in Sweden and Belgium, and also on the European level. Before I turn to the topic of the second session, let me say a few words about the interventions of the human rights defender in the courts. At the national level, the defender of rights can intervene as friend of the court before the courts, judicial and administrative, at any level of the proceedings to prevent this analysis of the case. He can intervene before the Constitutional Council, but he cannot seize it in the framework of the priority question of constitutionality. I am therefore very interested in hearing from our counterparts who have such powers and who have used them, in what framework and how did it happen. In 2021, we have submitted 175 decisions with observations to the courts. In 82% of the cases, the court decisions confirmed our observations. I'd like to insist on this figure, which is very important. 82% of the cases, the courts followed us. The defender of rights can also intervene before the European courts. We will also have some very interesting cases presented, most of which are referenced in our participant booklet. Before the ECHR, we have intervened, for example, in cases concerning unaccompanied minors or identity checks. very sensitive topics in France. However, we have rarely brought cases of discrimination in the strict sense. Before the CJEU, the European Court of Justice, we have very little involvement due to the lack of visibility of ongoing litigation and the lack of access to the third-party procedure for equality bodies. It seems essential that efforts be made to improve access to the court given the expertise of the equality bodies. We will have the opportunity to discuss this again. The exchanges will allow us to compare the modalities of interventions before the two European judges, the CJEU and the ECHR, and to evoke the difficulties of access to our counterparts for these two very different procedures. The second session this afternoon will look at other ways in which equality bodies for equality of treatment can work towards equal treatment in relation to their litigation and court work. Whatever their powers and qualities, if the bodies do not share the same culture and of non-discrimination law and its procedures with the lawyers, magistrates, associations who are at the origin of strategic litigation, their potential is therefore very limited. It is therefore necessary, in parallel to strategic litigation, to develop other types of action to ensure that the law is a real vector for social transformation. This includes creating a favorable legal environment and for non-discrimination law. It is therefore essential that we take a step back and decide on our strategic litigation priorities in conjunction with planning the use of our other powers. On this occasion, we will have the pleasure to hear the experience and expertise of Tina Semanovich Einwalter, Ombudswoman of the Republic of Croatia, and Romanica Lordache, human rights researcher, expert of the European Commission's Equality Rights Network in Romania. To conclude my introduction, I would like to mention one of the last cases we have dealt with at the Human Rights Defender. Recently, it concerns a man who reported racist remarks by his colleagues and who had been excluded from the work group by his employer after reporting these facts. Our investigation showed that an internal investigation was carried out following the employee's report, but that it concluded that the inappropriate comments had been made in jest. We made representations to the Conseil de Prud'homme, the court of first degree for individual disputes between employers and employees under private law. We recalled that the absence of humor could not be validly invoked against an employee who had suffered discrimination. We qualified the facts as discriminatory and moral harassment and held the employer liable as it had failed in its safety obligation. The Prud'homme, so this first instance, accepted the existence of moral harassment, which they compensated, but not discriminatory harassment. On the 25th of March, the Douai Court of Appeal rectified matters and ruled that the employee had been subjected to behavior that characterized discrimination. It also committed moral harassment and the employer's failure to fulfill its obligation to protect. On the other hand, it held that no separate damage was shown to have been caused by the Therefore, the employer should not be ordered to pay additional compensation for the discrimination. This very recent example illustrates the effective result of litigation in an individual case. Such litigation is important to provide concrete answers to victims, but as you know, their number is still insufficient. In recent years, we have had extensive discussion with our counterparts on this issue of non-recourse. The extent of discrimination is not reflected in the number of our complaints, particularly on the basis of origin and even less in the courts. Many factors contribute to this non-use, and you know the systemic characteristic which remedies in creating a form of discouragement, fatigue, a lack of awareness of rights and remedies, the fear of retaliation, which is a real fear, and also the difficulty of proving the facts. The Anti-Discrimination.fr platform, which we created last year in February 2021, aims to remedy this. It allows for a significant amount of time and quality of listening and has already led to a 25% increase in complaints about our anti-discrimination mission. Some of these complaints lead to litigation. But beyond individual redress, the fight against discrimination must have a more global scope. Class action is one of the possible levers. We worked on this issue 6 months ago during a study day entitled From Collective Mobilization to the Recognition of Systemic Discrimination in Law. This type of recourse, this type of appeal is developed in a number of European countries. It allows multiple claimants to denounce discriminatory systems that are rooted in the very functioning of organizations, but this progress remains fragile. To consolidate it, we must continue our efforts both with civil society and the judiciary, and with national and European legislators. Associations and claimants, by alerting us, can help us evolve and progress in our practice of law. Without a dynamic and daring civil society, we will not be able to progress. And civil society has a very important role to play. These are the few thoughts I wanted to share with you before beginning our discussions today and tomorrow. And I will now give the floor to Isabelle Rorive, who will start our work. Thank you very much.
Bonjour à tous. Je suis Isabelle Rorive. Je suis vraiment très heureuse d'être ici aujourd'hui. Merci à la Défenseure des droits pour son invitation. Je suis très heureuse aussi pour...
The interpreter apologizes. We have no sound for the moment. Il est... Still no sound for the moment. Apologies.
Je recommence pour les spécialistes. Donc, voilà.
So I will start again. Hello, everyone. I'm really delighted to be with you today. My name is Isabelle Rorive. I am a teacher of at the Faculty of Law in Brussels, and I thank the Defender of Rights for the invitation. I'm in fantastic company today since we have two representatives, three representatives of Promotion for Equality, members of the European Union, Karin, who is next to me, for the Swedish Ombudsman, Stevens for the Irish Commission, and Patrick for UNIA, the Interfederal Belgian Centre for Equality of Chances. This roundtable aims at debating on the role of bodies that fight for discrimination against courts, European or national laws and courts. And we know that European directives provide and offer us with minimal standards to promote this equality of treatment, since these bodies must be put in place in all of the member states of the EU concerning the motive of the discrimination, which is gender and race or ethnic origins. And the missions that were given from the beginning, the directive in 2020 by the EU, the 2000/43/CE, are wide, but can define this, since we talk about supplying reports, independent reports, supplying recommendation as well to public authorities, leading investigations, and support the victims, those victims of discrimination in front of courts. And this is because of this support in front of the court. This is why we are going to speak today. This support can appear in different forms. That all of the bodies that promote the equality, there are mandates and competences that are different. It can be very simply about representing a victim in front of the court, either by sending a representative lawyer firm. And Patrick Charlier from UNIA will talk about this when a victim isn't identified and the Court of Justice of the EU launched an action. It's a popularis action, as it is called. And discrimination can be recognized without victim. You can also, and the number of countries enabling this is limited to subscribe in group actions, or also to intervene in the framework as amicus curiae, friend of the court, for third parties' interventions, to supply observations in order to shed light on the stakes that are in question. The purpose of this roundtable, the first roundtable, is really to benefit from feedback from three bodies that promote equality of treatment in Sweden, Ireland, Belgium, where it is well settled. There were embryos where other organizations existed before the European directive, so it is not this is why there's actions that can be led, but nevertheless, these bodies have a different vision of litigation. They will talk about it for different reasons. The reasons can be because of the legal entity, culture. And so people easily go to court. It's different. You solve conflicts easily. Patrick Charlier will tell you that in Belgium it is very different. And in Sweden, as I have understood, it also depends on the impulses of the ombudsman, who, depending on his or her personality, will push for an important, more or less important litigation. So the culture of litigation is important, but we also, as Claire said, we also need to, it's about how you access to this jurisdiction. So a few words on the European jurisdictions, because often they're all put in the same bag. So, but the constraints, there are procedural constraints. If we talk about the European Court of Justice, we see entities to promote equal treatment that present cases to the court. It's on the national level, but the case will lead in front of the Court of Justice through the intermediary, because a question is asked to the European Court of Justice by a national judge. Thanks to this, the jurisdiction was restrictive in the way that in a Belov case from 2013, if I remember well, it considered that the Bulgarian Commission wasn't a jurisdiction in the meaning of the European Treaty and could not ask a question to the Court of Justice of the EU. This is important. It's important because the national institutions will have different competencies and skills, and they will, at times, they can answer to the quality of the jurisdiction, but often it is not the case. So how can a case be presented to the Court of Justice with the support of a national entity? Because we have convinced the national judge to ask a question to the European Union Court of Justice. Claire also said it in front of the Court of Justice of the EU. the fact of being able to act as amicus curiae, front of the court, as an intervening party, this is restrictive and is, I've checked well on the website of the Defender of Rights, it has not been done because the court regulation imposes criteria that are very strict with an direct interest in the litigation, and the third parties intervening, who usually intervene in front of the court, are the states or the European Commission or the institutions, but not the other parties. If we now take the European Court of Justice, it's very different. The European Court of Human Rights, it's different because you can have individual requests. You can also have used all the other means to do so. So it comes late in the procedure. It's a very long judicial time. It could be a physical person or a moral person, but if it's a moral person, in this case, the jurisprudence of the European Courts of Human Rights is also very strict in this way, since it would only allow it for organizations that are non-governmental. The jurisprudence exists on this topic, and in front of the Court of Human Rights, there's very few cases for this equality of treatment and anti-discrimination. The Irish Commission is one that did it, or the British Commission, but those are the ones who support one or more victims. Which could be more frequent, on the other hand, is third parties intervening in front of the Court of Justice. The Article 36 of the EU Conventions of Human Rights provides, is in the interest of a good administration of justice, to the president, in fact to the president of the chamber, the possibility to take in observations of the from the interested parties. So this is much wider, which means that third parties' interventions in front of the Court of Human Rights are frequent, but they come most of the time, they don't come from these entities that promote equality of rights. Most of the time from associations that are national, transnational, associations like Miliga Europe and others, or legal clinics, for example, which more and more will intervene now in Europe. And we'll hear the feedback from Ireland, since there was the third-party intervention in a case for gypsies, but the case wasn't won. Last body, it's almost jurisdiction, which is not very well known. The European Committee for Social Rights is in charge of the good application of the charter, the revised charter from 1996, and offers recourse. And Patrick Charlier will talk about it in his presentation. So very simply, without being technical, when we want to promote equality of treatment in front of jurisdictions, whether national or European, there's a whole context that you need to take into account, a national one, but also a European context for access to the different jurisdictions. We will go around the table, and first of all,
to be respectful the different person around the table. So the first questions I would like you to address, if I may, is what is maybe the legal culture about litigation in your country, and what is also the position with respect to Sweden, to the DO in Sweden. So thank you, Karen, to be here, and you have the floor for 5 minutes. Yes.
Yes. I'm from the Equality Ombudsman in Sweden, and I'm working as a head of litigation since February this year. And before that, I worked as a judge in the Patent and Market Court in Sweden. So it's quite a change of. I haven't much experience from discrimination law, but I'm very happy to be here, and it's very interesting to speak about these very, very important questions. In Sweden, we have a discrimination act that covers all sorts of discrimination that comes from the directives in EU law. and the Equality Ombudsman is tasked is to supervise this act in the Swedish society. And the Ombudsman is appointed by the government, but he is independent from the government. And that the Equality Ombudsman takes part of a long tradition of ombudsmen in Swedish law. We have a long tradition of different ombudsmen which are all independent from the government and from the parliament. And I think it's very, very important when we go to litigation and when we litigate that we are totally independent. And when we litigate behalf of the victims. So we will always be the plaintiff in our cases. And I think that will differ from different countries as well, what sort of position we have, but we always is the plaintiff when we decide to litigate for individuals. And the Equality Ombudsman has a number of different powers to struggle discrimination in the society, and I think the most important powers for today's discussion is the power to investigate cases of discrimination and the power to litigate. And today we have an organization where the investigating powers is organized in one unit and the litigation unit is quite small. For now we are just 3 lawyers, but we will grow to 6 lawyers after the summer. But we don't do the investigation, that's different lawyers who do that. And the Swedish Ombudsman used to go into strategic litigation and try to find cases which were supposed to be very important for the development of discrimination law in Sweden and in Europe. And the litigation team used to pick 1 or 2 or 3 cases a year to litigate them and put a lot of resources into these very, very important cases. And the Brattens case that we talk about later is one of these very, very important cases that the Ombudsman has litigated. But now, since we had a new ombudsman in Sweden, Lars, who is also in the audience, we had changed this strategic litigation, and we have a new policy which saying that we are for the individuals, and we try to help as many individuals as we can to help them to go to court to claim compensation. And to go to court and litigation is not always meaning that we are going to court. We settle a lot of cases outside court. And actually now we have settled almost all the cases we have started this last 6 months. So now we're trying to figure out how we should be able to take and to hold this very important case to go to court, because we realize that we need cases to go to court to develop the law and also to set principles in the law. But also we see that this sort of when we try to settle cases outside court, we get very much publicity, we get debate, and we get a huge discussion in the society about our cases. And we see that even though we don't go to court, we are able to change a lot about going to litigate for these individuals. And we think very much that we need these stories from individuals to promote and to see and to describe what discrimination is like in the society, because otherwise it's quite hard to understand that a country like Sweden could have cases of discrimination, but we do have that. So that was, thank you.
Thank you so much, Karin. And so we see really clearly the difficult balance between strategic litigation on the one hand, so having precedents, changing the law through cases, and at the same time helping as many people as you can. So Stéphane, your turn.
Merci Isabelle.
Hello everyone, it's a great joy to be here. Thank you for the invitation, for inviting me. It's my pleasure to be here. I will switch back to English.
I am from the Irish Human Rights and Equality Commission, which is an organization that was set up by statute in 2014, so we're still quite a young organization. And our functions include the protection and promotion of human rights and equality, and also the promotion of an understanding of the importance of human rights and equality in Ireland. And in order to help the Commission further these goals and to perform its functions, we've been given a range of powers. And of course, the Commission, one of these powers that the Commission has is litigation, or by legal means generally, I suppose. And I'm just going to describe some of the most common powers that we have in the legal team in the Irish Human Rights and Equality Commission. So the very first one, which occupies probably 40% of our time, I imagine, is giving legal assistance to private members of the public. So if somebody experiences discrimination or a breach of their human rights, then we can grant them advice and representation before any court or tribunal in the country to assist them with that. If for any reason a person who has experienced discrimination cannot or will not bring such a case themselves, then we have the possibility to do what Karine has so well described, which is to bring in a case in our own name. So in other words, we are the plaintiff in this procedure. We can do that under two mechanisms. One of those mechanisms is under our own Act, the Irish Human Rights and Equality Commission Act of 2014, and the other one is under equality legislation, and that's under Section 23 of equality legislation. We've only ever utilised that particular power, the Section 23, once, and it was in relation to discriminatory advertising, and we were able to successfully sue an online property advertiser for discriminatory advertising. And I suppose having exercised that power once, obviously, we have some experience in it now, and we would like to exercise it maybe a bit more. Another one of the more common powers, I suppose, that we use is the power to apply to the superior courts for permission to intervene in important cases as amicus curiae. So as colleagues will be aware, if a case involves a serious breach of human rights or equality, and we think it might be of strategic importance or of general importance, as the case may be, we can apply to the superior courts to come on board as amicus curiae. And we do that, I would imagine, probably about maybe 5 or 6 times a year. So we've got quite a few of them under our belt at this stage. We've done some really interesting work in equality in that regard. Recently, we're waiting on an important decision in a case that involves the rights of disabled persons. We can also, if need be, go to a European level. So as Isabel kindly mentioned at the outset, we've been involved in a case before the ECHR called Faulkner, which I might discuss a little bit more later on, a very interesting case about the rights of travellers. And we've been to the CJEU as well, involving, I suppose, a more maybe technical point of European law, which involves conflicts between national and European law as well. I'm very happy to discuss that later on too. And one very serious power that we haven't actually had an opportunity to exercise yet is the power to conduct an inquiry. So if it appears to us that there is a systemic and serious and ongoing breach of human rights or equality, we have the power to do an inquiry into that if it is a cause of real public concern, if it appears appropriate to us to do so, and so on. It's quite a high standard, and perhaps for that reason, we haven't done it just yet. We're waiting for an opportunity. And the final power that we exercise in the legal team is what's called an equality review. And this is an audit of the equality of opportunity that exists in a particular organization. I'll talk about this some more in a while, but just to give you a flavor of it for the moment, it's not, I suppose, litigation as such. It is in some ways, I suppose, an attempt maybe to avoid litigation by engaging with a discriminating party and inviting them to review their own procedures with a view to improving them with our supervision, if you like. We've exercised it quite a bit. It can be very effective, and we will continue to exercise it in the future. So those are our main powers. That's our culture of litigation, if you like. I suppose if I was to summarize, I would say, and I'll come back to this point, that we've exercised all of those powers. Colleagues will appreciate the exercise of some of them is not straightforward. Even though we have the powers by law, it is not straightforward. Some are easier than others to do. And we have found in practice that a combination of them, and also a combination of other powers that we have as an organization, including media, including policy, research, strategy, and so on, all of those things together can be very effective. Thank you.
Thank you, Stephen. Patrick?
Patrick, you have the floor.
It's a pleasure to be back here, and I will follow in French and a little bit in Belgian. You will see why. So, donc je viens d'UNIA. UNIA.
I come from UNIA, the Interfederal Union for Equality of Chances and Fight Against Discrimination. This is why we call ourselves UNA. Our official name is much longer. We are one of the two bodies for promoting equality in Belgium. There is another one which is for the equality of men and women, and I think the person will be here with us tomorrow in the morning to talk about gender issues. We are also recognized as a body regarding Article 33.2 regarding handicapped people, and I'm saying this as part of our strategic litigation. We are trying to make sure that this convention is also applied in order to have direct impact being acknowledged. We are also a national institution type B, except for gender issues and discrimination on the basis of languages. We are also competent for all the other criteria in the Belgian law. And according to our calculations, we are probably between 18, 20, 22 criteria. But just to give you an idea of the number of criteria that we have, the singularity of UNA as an equality body compared to other bodies is that we are both competent to handle litigation and discrimination, rather, and also hatred, acts of hatred, assault, aggressions, etc., violence through legal sanctions. We are also competent for hatred speech, even regarding the Nazi regime. In the Second World War, we've been in existence since 1993. We've been active since 1993. At the time, the creation of the Center for Equality of Chances was developed because we realized that the legislation against racism was not very well applied, or very little applied. So the authorities decided to create this new institution in order to go to court and to create case law in terms of fighting against racism. There were very, very few decisions at the time, either there were no achievements. So the reason we had this UNA was in order to create case law. And figures show that between 1993 and the beginning of the year 2000, the number of cases exploded. The European directives also brought the following point, which is fighting against discrimination and taking it out of the legal domain with hatred speech and other such topics, in order to move it to a more civilian procedure without intention. Now, in the various cases which we are dealing with, 35% of our cases have to do with discrimination, 20% with hatred speech, and 20% with hatred actions. Last year, we received more than 10,000 reports, which means people who reported of such acts, and we opened up over 2,000 cases. We can resort to court with the victims on our behalf. We don't represent the plaintiffs as such, but we go there in our own name. And the plaintiff, the victim, is there. We are there to support them. They have their own lawyers. We have our own lawyer, which means that at times we have to find systems so that the workload be on us in order to avoid the cost of the procedure to be too heavy for the victim. It's a way of helping our victims. Therefore, we negotiate with our lawyers to have a flat fee to make sure that we do not go overboard and having too costly procedures or costly procedures fees. It's a very sensitive issue. This year, we have received an additional fund to help the victims. This is something which we had been asking for a long time. Now, our priority today is to look for extra legal solutions whenever we can, whenever we want. We go to court, and we do have a number of criteria between 15 to 20 times a year for civil or legal or criminal procedures. When do we go to court? If the case which has been submitted to us has to do with law, when we believe that there is an interest to help the case law to evolve and to be more clear on certain issues which sometimes are not clear. So we go to court in order to have these points clarified. Another reason for going to court is regarding cases which may not be of a legal interest but which may have a societal interest. Going to court raises exposure to media, and therefore this is an opportunity to show and to highlight discrimination and to turn it into a societal debate. Another criteria, whenever there is a situation with very case law or very cases, and then we create case law on a basis of a criteria, maybe a small criteria, which for us is very important. For example, physical characteristics. We have very such cases, but recently we had one, and we decided to take it to court to create a case law. I will end my introduction by saying that an inter-university study covered 10 years of anti-discrimination legislation from the civil aspect. This study will release the results. The results of this study will be released very soon. And the results show that when somebody goes to court on the basis of discrimination, the rate of success is only 33%, sorry. This case can go up to 60%. The rate of success can go up to 66% when the case is taken to court, with the UNA, with our commission, our institute, from 33 to 66%. We realize also that the anti-discrimination laws are not very well known by the lawyers, by the magistrates. And this has happened twice over the last few months when we go to court because the first instance for appeal, because the first instance was not very positive, very good. We decide then to go to appeal in order to bring our own expertise and work with our own lawyers. Thank you, Patrick. What we can see after this first roundtable is a variety of skills and competencies which 3 different bodies have, with different tools, tools which are not so well known, like the Equality Review, which is a tool that is not as frequent, in my knowledge, among the other 27 EU members, which is an important tool. We also see the importance of taking position as to when to go to court. Sometimes the positioning can be linked to ideology, but sometimes also linked to available resources. Patrick mentioned this. This was one of the difficulties in Belgium, the necessity to find the additional resources on top of the annual dotation in order to promote equality of treatment. Another pivotal element is the training of the magistrates and the lawyers. As a university teacher, sometimes I go crazy when I read some of the results and some of the decisions. I'm teaching the students today so that they would not make the same mistakes.
Gone round, and I will start with Ireland because we have Fida Marouf with us. He's online. So thank you. Yes, we can see you. You are in full screen. Everybody can see you. So thank you so much to be with us today. I know you couldn't come, unfortunately, you couldn't come in person. And so I will give you the floor in one moment, but what I wanted to say, just a few words, is the fact that you came from Syria a few years ago, your wife in Ireland, and you faced discrimination because you couldn't open a bank account in a bank despite your refugee status. And so you fought really hard with the Irish Commission to change the law, the practices, and we are listening to you. You have the floor. Thank you so much for being here today.
Thank you very much, Isabel, and thank you for the French Defender of Rights for inviting me for this conference. I'm happy to be here, and I highly appreciate the opportunity to speak on discrimination as a person who went through this experience myself. So, as you said, I'm originally from Syria. I fled my home country due to reasons that you may all be aware of. I ended up in Ireland in 2016. And I saw asylum in Ireland, and I was given the refugee status. Subsequently, I moved to Dublin City, and I could secure my first job in Dublin shortly after that. I was not aware of the importance of bank accounts for employment, so I thought that my employer could give me a check, and I can go to the bank and exchange it for cash. So that's how naive I was in that regard. However, it was not the case. So I went to a well-known bank that has a branch near where I live, and I applied for a new bank account. I presented all the documents that are required, and I was told that the bank account details would follow shortly, but they have never arrived. I waited for a few weeks, and I followed up many times with the bank, but every time there was a new document to sign and new excuse for the delay. So eventually I gave up, and I went to another bank and I asked for a new bank account, and I was told that this is not possible at the moment because of my nationality. So bearing in mind that at that time I was working but not getting paid, and that added huge pressure on me, given the fact that I was also, like, I borrowed money from my friends to support myself in the meantime. So I left the bank on that day, suppressing my feelings of anger and rage. And on my way home, I met an Irish friend to whom I told my story. And he got frustrated, and he strongly advised me to go to the Irish Human Rights and Equality Commission to take a legal action. But honestly, I was not really keen on doing that because I thought, it would be okay if I try another bank. Later in that evening, I contacted few Syrians to check with them which bank was the least problematic in their perspective, but there was none. Every person who I contacted had an issue with different banks. But unfortunately, none of those who had troubles reacted to this discrimination due to fear of negative impact on their situation in the country, or the lack of the language, or the lack of the knowledge of the system. So I contacted my Irish friend, and with his help, I reached to the commission, the Irish Human Rights and Equality Commission, and they approved my request for legal assistance. So I was neither looking to punish the bank that refused me, nor to any compensation. Honestly, I was only looking for a way to prevent this from happening again to anybody who might be in a vulnerable position. So that's why I went to the hearing, declining the bank's offer to settle. And it's not a secret to say that it was a long and stressful process. In fact, it was terrifying. At some stage, I was afraid because I'm going to fight, or I'm fighting a big, powerful corporation like a bank. Like it's terrifying. In the time that I had no power at all. However, there was always reassurance by the commission, by Stephen as well, who gave me full control over the case. So I remember, all the time, Stephen used to tell me, you can stop at any moment, at any time, at any stage, and you can walk away without any consequences. And that made me go ahead until the end. And luckily I did. We went through the process until the final decision, where the bank was ordered to engage directly with the Irish Human Rights and Equality Commission to put solid measures to avoid the experience from reoccurring. And I think that the results of this case didn't only give me the confidence to stand up for myself, but also it was a strong message to other refugees in Ireland to trust the justice system and to follow the right path in order to obtain their rights instead of anger, rage, or isolation. So finally, I just would like to thank my great Irish friend, Mike, who introduced me to IREC, and for his support, and Stephen, and the Irish Human Rights and Equality Commission for their fine work to defeat discrimination in Ireland. And I thank you all for your attention.
Thank you very much for sharing your story. And Stephen, I let you carry on because you were very much involved on this case. It's the same when I always tell my students when we have cases of discrimination, if I have un visage, a picture of somebody, of someone, I show the picture. Because behind discrimination cases, we have faces and we have to confront and to see these faces.
Oui, c'est absolument vrai.
Yes, it's absolutely true, Isabel. It's perfectly true. Thank you, Frida. I hope you're still here. Frida, thank you for your story and for your courage.
Far more eloquently than lawyers can. And that lived experience was so important in helping us to do what we did with Fida's case and after Fida's case. So we became interested in the issue of bank accounts for asylum seekers and refugees after a case in Ireland called NVH, which was in 2017. And NVH concerned a ban on an asylum seeker's ability to work in Ireland, which was, if you like, permanent. And the Supreme Court found that permanent ban on asylum seekers being able to work was unconstitutional, which seems obvious in retrospect. At the time, it was not certain. And so, in effect, they gave asylum seekers the right to work with that decision. After that decision, we began to notice that there were certain practical barriers that asylum seekers faced in being able to access the labour market. One of these, for example, was driver licenses. Asylum seekers in Ireland, and I'm sure in other countries, live in quite remote, isolated areas, rural areas. They need to be able to drive to get to work. They need to be able to drive for work, for delivery, and so on. They need to be able to drive for childcare reasons, and etc. the Irish state refused to give them driver licenses, even to let them apply for driver licenses, because it said that they didn't have the correct form of residency. They wanted asylum seekers to produce an EU passport or evidence that they were permanently resident in Ireland, and of course, asylum seekers don't have that. Another barrier to asylum seekers being able to access the workplace, of course, was bank accounts. And FIDA has described this very well. Without a bank account in today's society, you can't get paid, you can't even be employed. And of course, that situation only got worse during COVID lockdown restrictions. So having learned about these barriers, we set out to, I suppose, confirm that these problems were real. And we did this through an outreach program. We began to contact, as Isabel was referencing earlier on, colleagues in non-governmental organizations around the country who worked with asylum seekers and refugees. And we took advantage of Ireland's small size. We got in cars and we drove around the country to speak with asylum seekers and find out what was the nature of this problem, what was going on, how widespread was it, and so on. In doing all that, we also, by the way, when we were speaking to asylum seekers, of course, asked them about all the other barriers they faced, including driver licenses and so on. And when we did this, we realized two things. The first thing was that asylum seekers were very willing to complain about not being given driver licenses. They thought that was very wrong, and they were clear that it was discrimination on the ground of race. No problem there. The other thing, as FIDA has alluded to, is that they were very much not willing to complain about the banks. They thought that the banks had all the power, they thought the banks could do what they wanted, and they were concerned that if they did make a complaint, that this would in some way have a negative impact on their status in Ireland. So we had to keep on looking for clients to go forward on that issue. And while we were looking, around about the end of 2017, as FIDA has described, he came to us and applied to us for legal assistance. Now, FIDA has described very well how scary the process was for him, but at least the one thing I suppose he didn't have to worry about was his status in Ireland. He had refugee status, and so he at least had that bit of security. As he has said, he walked into a bank, and I think if anything, FIDA has understated the treatment that he was subjected to. He walked into a bank, showed them his refugee travel document. They took it from him. They examined it. We saw all this on CCTV footage that we got afterwards. Two people looked at it. One of them came back and said, "I'm sorry, we can't open bank accounts for Syrian people today." Shocking. So, as you will have seen, FIDA is a very eloquent, very well-spoken man. They absolutely picked the wrong guy to mess with. So FIDA came to us, I'm glad to say. We granted him legal assistance to make a complaint to the Workplace Relations Commission, which is Ireland's equality tribunal. And the tribunal in its decision confirmed that indeed FIDA had experienced discrimination on the ground of race. And as FIDA has said, what was crucial here was that they also ordered the bank to engage with us for 6 months to prevent this kind of thing ever happening again. So this was a great opportunity for us to see into the banks and discover what they were thinking. So we sat down with them as much as we could for 6 months. We met with usually a manager and a lawyer. We asked them about their policies and procedures around equality, what their attitude to discrimination was, did they think they were doing enough, and so on. They made certain commitments to us. You know, I should say that FIDA's case, which is a Syrian refugee and a bank, received an awful lot of publicity in Ireland. Of course it did. We put it everywhere. You know, we really wanted to publicize this for banks and for refugees. So the bank had no choice really but to act to some extent on it. So it did, and there was improvement, but it was not enough. We were not convinced that there would not be more discrimination. So we kept on going with them, and at the end of the 6 months, we reviewed the situation. And the situation was that we had continued to receive more complaints of discrimination from other banks. And some of these banks were now, if you like, worse offenders than the original bank. So we considered our options and we decided to proceed by way of, as I mentioned earlier on, an equality review. And there were a couple of reasons for this. First, as I say, there were few asylum seekers, if any, willing to come forward and complain about the banks, so we couldn't represent anybody. In terms of maybe taking own name proceedings, there were certain risks and complications with that. And of course, there was the potential for the banks to defend those kind of proceedings vigorously, which would have involved a delay, which would have meant that the problem would not have been solved potentially for years. You know, who knows? So we proceeded by way of equality review. Excuse me. The equality review process in short is this. First of all, we invite the organization to do an audit of their equality of opportunity systems and report back to us. If they refuse to do that, or if we don't like what they say, then we proceed to what's called an action plan. In other words, we ask them to tell us what they're going to do to put the problem right. If they refuse to do that, or if we don't like that answer, in that case, we can do the equality review. In other words, we can do the audit of their systems. And if we still don't like that, then we can do an action plan. In other words, we tell them what to do. And failing all else, we issue them with a substantive notice, and the whole thing might well end up in court. So we went for stage one. We picked the two worst offenders in terms of banks, and we sent them an invitation to do an equality review. And this meant essentially correspondence. We set out who we were, we set out what our powers were, we set out the nature of our concern, and we asked them a lot of questions about their policies and procedures. And we asked them for some documents as well, which we were licensed to do. And of course, the banks took this seriously for a whole number of reasons, not least of which FIDA's case. They had seen this. This was in the air. And so they did engage with us, and we were satisfied with the level of engagement and cooperation that we got. They sat down with us. They sent over armies of lawyers and managers and so on to meet with us and tell us why they were doing everything properly and correctly. And we argued back and we said, I'm afraid that you're not, and here are the reasons why, you know, your equality practices may be a bit deficient. So this went on for 2 years. COVID came along, delayed things, of course, and in the end, it came down to one thing, and that thing was the temporary residence certificate, which is the state-issued document in Ireland that shows that somebody has applied for asylum. And written across the temporary residence certificate in red letters, big capital letters, it says, this is not an identity card. So we said to the banks, when we'd answered everything else, we said, if you list this and other state-issued documents on your website as being acceptable for the purposes of opening bank accounts, problem solved. We'll leave you alone. And if you don't do that, then we're going to take further action against you. And we gave them a deadline, because deadlines are very inspiring. We said May the 14th of 2021. And on the 13th of May of 2021, the banks announced an exciting new initiative. And their exciting new initiative was that they would now accept state-issued documents from asylum seekers for the purposes of opening bank accounts. And of course, we welcomed this initiative. We thought it was great. So since then, since May of last year, just slightly over 1 year ago now, I'm glad to say that asylum seekers in Ireland are able to access bank accounts. So we had solved one of the roadblocks to being able to access the labour market. The other one was still there, driver licenses. In this case, as I have said, we had no shortage of asylum seekers willing to come forward to complain. It was very different because it was a state actor. And we had many volunteers. We narrowed it down to 3, the 3 strongest cases that we could find based on the facts and so on. We ran them to the Workplace Relations Commission, which again is Ireland's equality tribunal. And one of those cases was refused for want of jurisdiction. They said that they had referred the case out of time. We disagreed, of course. However, our client got permission to remain about that time, and he decided not to appeal because, of course, he could now get a driver's license himself. So that left 2. In the other 2 cases, the tribunal decided very clearly that the refusal by the the refusal by the Road Safety Authority to give asylum seekers driver licenses was discrimination on the ground of race. Wonderful decisions. In one of them, they ordered the Road Safety Authority to meet with the person and give them their driver license. In the other, they said essentially the same thing, and they also ordered the minister to review their practices around giving asylum seekers driver licenses. Great times. Of course, both of those decisions were appealed. We then gave the asylum seekers legal assistance to cover the appeal to the circuit court. In the circuit court, one of the cases was settled for personal reasons for the asylum seekers, so 2 had become 1. And unfortunately, in the circuit court, that case lost. So we now gave our client additional legal assistance to cover an appeal to the High Court. Our client went to the High Court, and unfortunately, on that instance, we lost again. And at this stage, you can imagine our client had been through the tribunal, the circuit court, the High Court. As Fida has said, 1 case is a lot. 3 for a vulnerable person in asylum accommodation is an awful lot. So they decided that they didn't want to appeal anymore. And for a while, it appeared that we were going to be left with this unfortunate High Court decision. But as I say, thanks to the media and our publicity, this was out in the air now. And private solicitors, private lawyers in Ireland were starting to do things about this too. So a private solicitor had taken a case called L and the Minister for Transport, which involved a South African couple of asylum seekers who were challenging the Road Safety Authority's refusal to exchange their valid full South African licenses for Irish ones. So the High Court gave us permission to become involved as amicus curiae, and we came on board and we gave the court the benefit of all our expertise and experience that we had accumulated in those other cases. We told the court, asylum seekers do have lawful residency in Ireland. Of course they do. They do have documentation that's acceptable for the purposes of getting a driver license. And crucially, of course, the decision not to give them those driver licenses is discriminatory. And I'm delighted to say the High Court agreed with us and said in a very strongly worded judgment that was not appealed, of course they have lawful residency in Ireland, of course they're entitled to do this. And so I'm glad to say that from October of last year, asylum seekers in Ireland have the right to apply for driver licenses and the right to apply for bank accounts. So if I was to summarize, I suppose I would say you can hear the number of powers that it took us to achieve this. We had to be able to represent people privately. We had to be able to become involved as amicus curiae. We had to be able to publicize these things. We had to be able to exert political pressure. And what I would suggest, I suppose, to close is that it's maybe not only one power or one piece of litigation is going to achieve the desired result. It's a combination of them that exerts pressure in the right places that can achieve the desired result.
Thank you. Donc,
so very clearly, in this type of case, which could be qualified as systemic discrimination for asylum seekers, we've heard elements, other discriminatory elements on differentiation, a system that at the same time the refusal from the banks, but also public authorities, we see that the path is very long to lead these kinds of actions, strategic actions, and it is important in these cases that end up successfully to take the measure of time and resources that are put at the service of these cases compared when you want equal treatment. And I'll start with Patrick because I can see the right transition, knowing well the Belgian case, the transition I can make with Patrick. So I was told that we should take our time. We won't go round the table again, but we will be able to present the element we wanted to present later. So if you want to say something about the European Commission, you can. All right. What I heard really echoes very strongly on the situations that we know about. Just one thing concerning discrimination of people who are asylum seekers or in precarious situations. We've received a file. It's called the Semanovich File. It was a woman from Ukraine who didn't have a paper. She was in a precarious situation, and she found housing. And as the Belgian law says, she had to put some money on a bank account, which was done. But after 3 weeks, the money closed the account because she didn't have a residence permit. So this also shows the position of precarity in which we are. It's the owner who thought it was such a scandal that he contacted us and sent the case in front of the court for his tenant. So he took in charge the expenses to go in front of the court. And for us, I don't know if it's this discrimination criteria. For us, it wasn't obvious that it was based on race, and this residence permit is not protected by law. So we had to go in front of the court to say that by definition, it is someone who was a foreigner who had a problem with the residence permit, and it was an indirect discrimination based on nationality, on origins. This is how the bank was condemned for discrimination thanks to this mean. Well, I'm going to close on this because this is not what I wanted to talk about, but to come back to the question of the position, the place of the victim, and concerning European procedures, we had 2 files, 2 cases of jurisprudence, of case law. Madame Ajvita wanted to wear a scarf. She was dismissed because she wanted to wear her scarf. And before going into details, it's a procedure that lasted for over 10 years. There was a first instance, and it went to appeal, then to Luxembourg. After 10 years, she didn't want to hear about it anymore. She left for Belgium. She went to England. It was a difficulty for her. But the duration of this procedure was horrible. She didn't want to continue. But the case was an extremely strong one, important one. In this case, in terms of strategic contentions, from the beginning, litigation, from the beginning, we conceived, designed the case in first instance during the appeal. We realized that when we are working on these cases and we want to talk about these prejudices, the tribunals are not ready to hear that. And maybe the high instance did it in some cases very well, but during the first instance and for the appeal, it's not easy to convince the courts. Regularly, we're confronted to that in the conclusions we offer it, but it's not often. So maybe it's a question of procedure. I talked about it with a magistrate, and he said, if I am a magistrate and if I ask a prejudicial question, it could put me in an uneasy situation, because if I ask this, all the litigations for other cases, I will obliged to wait to have the answer. So it is not only for the prejudicial case, but for similar cases that I will have, and that I will have to suspend. And we know how long procedures take in Luxembourg. This is one of the difficulties that exist. The other being in the arbitrage case, it is a case that cost us several hundred thousands of euros, because when I said 700,000, it's really more than 100, right? So all the time of the procedure is extremely costly, even if we have a certain budget. And even if we're careful in these court cases, you need to choose them because it has a very strong cost and impact. In the EU, there's a refrain. I don't know if you know that. The fact of cause, Mr. Ferrain installs garage doors, and there's a big sign on the highway saying re-recruit. And at some point, a journalist came to see him and say, "How come you're recruiting?" "No, I recruit, but no one foreign, never any foreigners. My clients do not like to see people from North Africa coming to their homes, because if they're working on the garage door, they could enter the house, they could steal things, and my clients do not like people from North Africa." He said this in the press, and this is a case where there are no victims. Of course, someone who is from North Africa will say, well, no, but there's no individual victims. Therefore, in front of the court, they say there are no victims. Who was discriminated here? This was the purpose of the prejudicial question and how to advance, how to make progress, because it is discriminative, even if there are no individual victims. And to promote equality, it is necessary to be able to go to court, even in the absence of individuals. Ferrain and Ashbita, these are cases on which we had a strategy. We deployed our sails and became visible. In the litigation case in front of the Court of Justice in Luxembourg, we also have a strategy which I call the Submarine Strategy, which means that we have all sorts of dossiers cases in which, ongoing ones, in which Belgium will intervene, because in this case, we can intervene, and we are solicited by the Belgian authorities to provide expertise and to settle the position of Belgium when it is going to plead itself a case. We did it, for example, in the Ring file, case against Denmark, and we helped feed the Belgian authorities with all the reflections that had taken place on the question of handicap. It was about acknowledging that a certain chronic disease could be equivalent to disablements. So we are working on cases today. There's a case Fernandez, once against Poland, in question of sexual orientation, and when someone hasn't seen his contract prolonged because people realized he was homosexual, and the person said it was because of this that his contract wasn't prolonged. So with our expertise, we were able to help. And Fernandez is a trainee who was wearing the scarf, and she was refused in the workplace because she was wearing the scarf. We also follow cases concerning a municipality which has dismissed or refused, rather, to authorize a lady to wear the scarf when she was working back office. So you see the strategic litigation here. It's to know what is public authority, what about back office, what is the difference. This is a case we are following carefully, and we must make choices, because in terms of budget, we cannot work on all fronts. And one of the means we have is to help lawyers, to give them information, to also give information to the court with all our expertise, our case law, but without pleading necessarily each time because of cost reasons. So I'm just going to finish, since you are suggesting me to do so. In another litigation at the Court of Human Rights, we intervene very little, but this is due to the fact that as promoting equality, we have the directives, the Charter of Fundamental Rights. We are less open, and we have less expertise. We less have at hand everything that touches onto these discriminations. But what we do, on the other hand, is when it's under our mandate, with the decrees, Belgium was condemned because a disposition that was very old forbade people in front of the court to take their hat off. So they had to take their hat off. So there are judges who imposed scarves being removed. For this decree, Belgium took a long time to modify it, but now it is done, and the problem is inexistent. But what we do, we intervene as a submarine, or in a more hidden way, or in terms of disablement. In Belgium, there was a case that was sanctioned or condemned by the European Committee because there had been not enough inclusive policies for children who went to school with a mental handicap, and they were condemned. And when this is done, we work intelligently with the different parties. There's an organization dealing with mental handicap also took part. All the case law, all the interpretation of the Article 24 was an argument that wasn't used by others. So we also worked in order not to repeat things in front of the courts. We also intervened in cases concerning the traveler community and people. There were right of Roma people, and there was a big case that had consequences on children and women. So we had to work to support the case when Belgium was condemned for a lack of, in terms of welcoming them. Thank you very much, Patrick. The submarine technique. I'm going to remember this expression. There were others, but indeed it is a technique that can be very interesting, and UNIA uses it also. It can go both ways with the clinics that you mentioned that we created with UNB, but not only this one. And they enable, in cases that are very sensitive, to avoid for the when we want to promote equality of treatment, as you said, you can say less, but I have my academic freedom to speak. I will not deprive myself, but in the Ashbita case, UNIA had really worked hard. It worked with all the criticism that it had to face, and things said about the cost that these procedures represented, and criticism that made more fragile the UNIA. So Stephen mentioned it also with Fida Marouf. There's never any perfect request, but in these strategic litigations, we try to find one person who will embody a cause and the best possible. So this is what Mrs. Mikulski said before me, a teacher for equality between men and women, when she presented different cases on equality, men and women equality, which doesn't exist anymore. It's the Sabina, a former aircraft company. It is important to investigate in places where this body of promotion for equality cannot be in the forefront, but can really share its expertise, namely with the state, And it is a way to come back to the European Court of Justice with interventions that are supported by the state and can be fed by the expertise of the organization. Karen?
So I know you have an experience to share with the Court of Justice of the European Union, and so you are the last one to have the floor. You can also, if you agree, say a few words on the fact that the DO doesn't have the power or the competence to act as an amicus curiae before the courts.
Yeah, I'm very glad to hear that you also find that these stories are very, very important to tell and to understand the discrimination. And I'm very sorry to not have all the powers that you have, because we are not able to intervene in courts that you do. And we always act as a plaintiff, and we always act in ordinary courts and in civil cases. So that's quite different from you, and we don't have all the tools you have to talk to them and to litigate in different cases and so on. But I will tell you about one case when we went to the European Court of Justice, and then we went to the European Court of Justice as a plaintiff. We asked for a preliminary ruling, and the Supreme Court finally did that preliminary ruling. Because we have the same experience as you have, that the lower court, the district courts are very, they don't want to ask the European courts. We have to go to the Supreme Court, and then they have, as you know, an obligation to ask the European Court if there is a case dealing with European Union law. And I was not part of the litigation team when this Bratton's case was brought to the European Court of Justice, but I worked for the Supreme Court at this time, and I know that this case is very, very important for Swedish lawyers, and it's very, very important also for European law, I think, because it struggles with this distinction between the autonomy of the national procedural system and the right for individuals to have the rights to proceed and rights to litigation in the national courts. And actually the facts in this case are not that inspiring. It was a man who was born in Chile, but he had lived for many years in Sweden, and he was about to take a domestic airplane between Gothenburg and Stockholm. And then he was denied, and he was forced to take a second security control. And the ombudsman said that this was because he had a different ethnical origin than it's not being Swedish. And we brought this case to the district court, and we said that this is clearly discrimination. And it was quite a low sum of compensation. I think it was 1,000 euros was the claim. And that was because it was very important for this man to have this declaration of discrimination. He wanted the court to say that this is discrimination. I have been discrimination on. And maybe that's different from person to person. For some people, this is very, very important. And that could be that they have been the victim of discrimination all their lives, or it could be different interests. But for this man, it was very, very important. But then, as I also recognize, the airline company went to district court with an army of lawyers. And they said very strategic that, yeah, we pay what you claim for, but we deny discrimination. And the poor district judge had to follow, or thought he had to follow, the Swedish procedure law in civil litigation, which says that if the parties can solve the case, the judge cannot judge on the case. So the district court just said that, oh, the case is over. They pay what you claim for. And then the ombudsman appealed to the appeal court. And the appeal court rejected the appeal and just said that, yes, the district court have followed the Swedish procedures law for Swedish litigation. So that's a correct judgment. And then was the appeal made to Supreme Court. And then the Supreme Court made a preliminary ruling to the European Court of Justice. And then the Supreme Court asked then if a member state must examine whether discrimination has occurred, if so requested by the person wronged. So the Supreme Court's question is about if the individual asks for examination of the discrimination, could the court then deny that right to have this discrimination examined, even though the defendant chooses to pay what the claim is. And this is a very, very interesting case, and it's interesting when the court answer. It's very much about access to court. And then the European Court of Justice says that both from the directive but also from the Charter of Fundamental Rights of the European Union, there is a right, if one must seek a declaration of the existence of discrimination, to have that declaration made by court. Only by paying, you can't have that right. You don't have an access to right, access to justice in that case. But then the case went back to Supreme Court, and then the airline company went to Supreme Court with the army of lawyers, and they said, now, yes, we paid as an act of goodwill, but now we see that, yeah, we could admit discrimination in the way we have to admit discrimination, because the European Court in Luxembourg said that we had to admit it. So this was not very much a admission from the heart. It was very much we do what we have to do, and we do it in writing, nothing more. But then the Supreme Court said that, well, the airline company has paid what you claimed for, and they had admit discrimination in this way that the European Court says should be done. So we have no case. We have nothing to judge over. So the case was closed. But then the Supreme Court, all the judges in the Supreme Court, they wrote a special opinion to the legislator and said that here we have a huge problem. We have a system of procedural law that is not the individuals can't get the rights from European law in this system. So the legislature have to look into this problem and change the law. And the court also said that we can't, by judging in one case, we just solve this problem for one person, but there will be problems in more people coming, and you have to look over the whole system. And this was half a year ago, and we haven't heard anything yet, but we hope that there will be new legislation soon. Yeah.
Thank you very much, Karin. We really see the importance of access to justice, but also the right remedy. What is a remedy, a correct remedy according to EU law? So I think now it's question time. So don't hesitate to ask questions, raise your hand. And I guess, yes, please.
Bonjour.
Bonjour, si vous pouvez dire dans la langue que vous voulez. Et si
You can use whichever language you want. Just say a few words who you are. Hello, I'm a member of the association Diaspora Vote to help understanding at a European level discrimination and such cases. Thank you for your presentation. It was very interesting to have a comparative approach regarding equality treatment in Europe. My question concerns the harmonization of practices. We know that every body has different powers, as you stated. When it comes to France, I'm speaking on behalf of France, being a French citizen. A few measures have been implemented, namely the Anti-Discrimination platform, which is very successful. This was an initiative from the Ministry of Equality of Changes with Elisabeth Moreno at the time. I do have a question regarding the systemic aspect of discrimination. I have the feeling that the defender of rights in France plays a role of ombudsman, also in settling cases. As you said, a great percentage of cases are confirmed in the observations. However, regarding the systemic aspect, in some cases, just to give you an example, at the end of the junior school, a lot of young pupils have criteria of discrimination, ethnic background, or country. In France, things are not quite there yet, even though things are already very clear at the European level. So how do we harmonize this at a European level, taking into account the various limitations of all the various bodies? How do we make all these bodies accessible to many citizens? I know that many people who suffer from discrimination, they don't want to go to see the defender of the rights. They think it's useless, that it's going to take too much time. How to restore trust and confidence between citizens and the various bodies? I hope I was not too long. Okay, do we have any other questions? Maybe in the room, we have several people who are following us also online. So let's take a few more questions from the audience.
Statsky from the Austrian Ombudsman for Equal Treatment. Just a very short question to Patrick. Did I understand correctly that the people have to pay for if you present them before the law, and how is that? How is the procedure then? Thank you.
Monsieur.
Monsieur, Dame, Fabrice Molière, Secours Catholique.
Fabrice from Caritas France, a Catholic organization. Thank you for this symposium, both the presentations and our colleagues from the other associations. It's very, very important in terms of ongoing training also for us. It is so rich, we don't even know which question to raise, but anyway, trying to be short. Really appreciated what was said by Mr. Charlier when he used the expression even though when there is a discriminatory willingness, it is still discrimination, even though it's not been proved or supported by facts. We also had a meeting with various associations, a collective meeting recently, and we were talking about the way that our social benefits offices are functioning, that we should also work regarding some statements from the social security benefits, which sometimes have an impact on social benefits, with a number of restrictions in the access to social rights. I'm talking here about the CNAF. We believe that the heart of our action is locally and also intra-associations, also with the defender of rights. This is the heart of our action. But in order to better work and support our people, whether we do this with volunteers or social workers, and when we identify dysfunctioning, we raise awareness, we report these dysfunctioning. Yet at the same time, it is very important for researchers in social science to look at these laws. We regularly have a researcher who helps us to read the documents, the legislation. I'm just closing my question now. Please allow time for other people. people can understand what I'm saying, and I know you understand. I respect researchers greatly. I know you understand what I'm saying. Anyway, what I'm saying is that in the laws there are major contradictions. On the one hand, there is a willingness. People know about this. There is a willingness, a clear willingness. On the one hand, we hear great messages, speeches regarding the willingness of institutions and their willingness to fight against discrimination. And at the same time, there is a development of ideology in the media along with political leaders to say that there is too much fraud and there should be more control. Okay, I'm going to have to stop you. There are people online.
Dernière question, mais je ne sais plus qui avait. Voilà, merci.
Another question. Claudie Jacob, in charge of the judicial affairs at the Defender of Rights. Coming back to discrimination, I do have a question for our guest speakers. I think I know a little bit about Belgium. I don't know much about Sweden or Ireland. How do you finance actions by individuals? From what I understood, from what Mr. Charlier said, there is a support on the UNA budget. From the UNA budget, are there specific funds when it comes to strategic actions? How do you finance? How do you support financially victims of discrimination? Here we have a system of legal assistance, but we don't have the necessary means to take charge of the fees. Thank you. If that's okay, should we just answer these various questions? We're talking about systemic discrimination and the issue of harmonization and the financial aspects in terms of resources. These are all important questions. Patrick, would you like to take the floor? Okay. I can react to what has been said.
Sur une journée d'études sur le...
We were here in November. We had a workshop talking about discrimination, how to address discrimination, how to structure systemic discrimination. I think that's a main challenge of our day. How are we going to be able to recognize this? Do we have enough support, enough documents in our various social research, economic, societal research? Figures show this, and we know about this. And that's our role. And for us as promotion bodies, it's something that we think about, and to look at this issue and see how we can make these issues legal. It raises a lot of questions. Who do you turn to when there is systemic discrimination? Do you turn to the state? Do you turn to a particular area? Do you turn to a major employer? These are the questions which are raised. Who is responsible? This is a huge challenge which we must work on and turn this into something legal. Systemic, intersectional discriminations are not sufficiently recognized. Often I hear people say it has nothing to do with law, but actually it has everything to do with law. Secondly, you talked about the trust that people can have with or to the institutions. In Belgium, we carried out a research. It was a survey, rather, qualitative survey made by journalists rather than scientists. So victims were interviewed. And what came out is that these victims were people who had sometimes complained or reported something. And the survey asked them what triggered their approach, their decision to act. The victim needs a whole network of support. What does the victim expect from colleagues, from the family, from the various bodies? What do the victims expect from the police? So there were many recommendations. There is not just one solution. When you are in such a situation, you need to be able to mobilize a whole range of resources and be aware of what these resources are. There was another question regarding the financing. Now, regarding the procedure, we work on behalf of our own name. As I said, we both have our own lawyer. Why is this so? It is possible that at one point we may not have the same interests. It can happen that throughout the procedure, at one point, the victim may be satisfied with something, but we may find that it is not a good decision, and the victim might get compensation and decide not to continue. Or on the other hand, we think it's a good solution and the victim is not satisfied. So we don't always have the same interests. Of course, this raises a number of questions as to how to access justice and legal assistance. The threshold is so low in Belgium, it's very hard to mobilize this threshold. We try to find new devices and mechanisms for people to go to court. For example, for labor discrimination, we do have some protocols with unions, and they have their own services, legal services, and they take charge of all the fees. Other people have some insurance, and they can use these funds when they go to court. And we also try to find solutions in order to guarantee to the person who is going to court. And we say to them, look, this is going to cost you at the most 1,000 or 1,500 euros. And we negotiate with the lawyers, and we say to them, look, this is what we want. And we have a power of persuasion which the victims do not have. This is a word which we use in Belgium, spielerij. For some cases, we agree when there are two lawyers, and our lawyer take the greater load, so that the lawyer of the victim would not have so much work to do and would not have to invoice higher fees, and we carry most of the financial burden. We cannot pay for someone else. We are controlled. We have to mobilize a justice fund, which is a particular justice fund. One last thing to answer your question. When it comes to discriminatory regulations, we had this debate in November. We talk about objective litigation. The various bodies can mobilize the objective litigation to cancel some decisions which could be discriminatory depending on the text and documents. No mic. I cannot hear this gentleman who does not have a mic. The interpreters do not have the sound. There is no mic. We agree, of course, with what is being said. Stephen, you have the floor.
Keep it.
Merci. I will address this lady's questions. I just want to make sure that I've understood the questions properly. So the first one is how to address structural or intersectional discrimination. I think this is a really good question, and as Patrick says, it's something that we have to think about an awful lot. In Ireland, we have maybe a bit of an advantage in Ireland. We have something called public sector duty. which is one of our powers. It's really, really helpful. And public sector duty says, désolé que je dois parler en anglais. Oh. Ok, super, ça marche. We have public sector duty, which means that all public sector organizations have to act in accordance with human rights and equality law obligations. So this is really helpful. So if it seems to us, obviously, that a public sector body is discriminating against any group of individuals, we can quite simply remind them that they have a duty to act in accordance with human rights and equality principles. Now, again, this is one of those powers that we have that's still quite new. So we've been, if you like, I suppose, introducing it into the public sector domain for the past few years, and we think that there will come a time quite soon when, if public sector organizations still aren't doing what we want them to do, that we might have to lean on them a little bit more. I think your question becomes a lot more interesting and a lot more difficult when it comes to the private sector, for a number of reasons. The private sector is very well financed. We are not necessarily. And those kind of issues go very deep and can be quite complicated. At the risk of oversimplifying an answer, I think this speaks to the necessity for organizations like all of ours to be properly funded and to have the kind of means at our disposal to go after this kind of behavior. But it's a really interesting question. I wish I had a simple answer. I would certainly share it with everybody if I did. To go to the second question, Isabel, just to make sure I have the answer right, it is how to give people confidence in institutions like ours or institutions in society generally?
It was ours and general.
Okay. Again, I think that's a really good question. I mean, as Fida has explained here earlier on, and as you said in your comments as well, you know, we're well aware that we're only seeing the tip of the iceberg of people that come forward to complain, right? And for example, a couple of years ago, I addressed a conference of the leaders of the Muslim groups in Ireland, and there was maybe about 100 people in the room, and I spoke to them and I said, I know that people you know are experiencing discrimination. I know they are. So here's how they can access our service, you know. And I said, like, here's the application form, and so on. Here's write to me, you know. Here's my card, the whole lot, right? We didn't get one response, and I totally understand why that is. I really do. It's because it's okay for me to sit up here and tell people, you know, contact me and so on. But if you're on the receiving end of that kind of discrimination on the street or in a pub or wherever it is, you know, what we hear time and time again is, of course, it gets inside people. Of course it does, and it disempowers them. It prevents them from coming forward. So how do we reach out to them? I do think outreach is very important. I think it's important for organizations like ours to go out into the community and talk to people, and not only in Paris, not only in Dublin, you know, out in the countryside. Like, we have to go out there. That's, as I said before, that's a lot easier for me to say in Ireland. Ireland's a small country. But I think that might at least be a beginning of an answer, I think, because we're another institution. You know, we might think that we're the good guys. We're another institution, and that's how people see us, and it's difficult for people to get beyond that. And then to come on to the third question, which was how do we finance action for our clients? Nouveau, désolé que je ne peux pas parler en anglais. We have an in-house team of lawyers. There are we have got up to where you're going to be, Corinne. There are 6 of us now. We're very pleased, and so we're employed by the Commission in part to represent people. And we're lucky in Ireland in that the Equality Tribunal there doesn't have any costs, and it's designed deliberately that way. So if you can take a complaint of discrimination to the Workplace Relations Commission, and if you lose, you're not going to pay the other side's legal fees. So that's really helpful. Otherwise, for the bigger pieces of work, we have a budget. I suppose, you know, it's one of those things, the more successful we are and the more that we do, the more that we need, because it generates publicity. People come to us, oh, we don't have, you know, we don't have enough money to do that this year. Can we have more money? You know, and so on. We are independent. You know, we're technically the civil service, but we're a kind of an independent civil service. So our source of funding comes that way. I hope that begins to answer your question. Thank you.
Yeah, I will start with this finance. And I would say in Sweden, we are always the plaintiff, and we take all the costs for the victims we litigate for. But it is, and that's a problem we see, that it's very, very, very expensive to litigate in Sweden today, because we litigate like normal civil procedures, and then we have this army of lawyers coming on the other side from the big law firms that could put in huge amount of money in our cases. But fortunately, we haven't lost so many cases, so we haven't had so many costs for litigation costs. And we also have a special paragraph in the statute saying that if it was worth to going to court with this discrimination case, we should not be, even though we lose the case, we are not forced to pay for the defendant's costs. So that's good. But the victims, that's the most important, does not have to pay anything for the litigation. And then to the questions about confidence, and we have had times in Sweden where victims didn't come to the Quality Ombudsman because they said that the Quality Ombudsman doesn't do anything. We don't have any answer, we don't know what to do. And we have found out that that we do take cases for individuals, we do listen to people, that also give confidence to other people to come to us and tell them their stories. So we think that we could, by statute these examples, we will build confidence so that we could have people coming to us and tell their stories. And also we try to work as close as we can to different organizations and associations representing these minorities or disabled people or what it could be. But we are also a small country. We're not traveling very much in Sweden, and maybe we should start to do that. We're quite focused on being in Stockholm, unfortunately. Yes.
Thank you. Sorry, I tap on the microphone. On a encore du temps pour les questions? Ou il est...
Do we still have time for questions? I think there was one more question. Of course, please go ahead.
I'm Clara Zenfratz. I'm from the European Commission, working in the unit Anti-Discrimination in DG Justice. I just wanted to come back on the notion of intersectionality that was mentioned before, because it was said that it was recognized at the European level, and I wanted to clarify that this is not the case at the moment. There are only 6 grounds that are recognized in this treaty. So this is actually less than many equality bodies are working with. And for the moment, intersectionality is not in any of our directives. There is a recent proposal on pay transparency that mentions it in the recitals, but this has not been adopted yet. So I'm not saying here that it's not a reality, just that for the moment, the concept is not recognized. And as for structural discrimination, this is also something that we are aware of. And I will talk later about our legislative initiative on binding standards for equality bodies. And I hope that I have the opportunity to say how we thought, because it's not a proposal yet, but how we are thinking to address, or how equality body could address structural discrimination. Thank you.
Merci. Sur les discriminations intersectionnelles, la jurisprudence de la Cour européenne.
So the European Court of Human Rights provides more elements about this, and the case law of the United Nations also, as discrimination against women. We have an acknowledgement of intersectional discrimination. We are waiting very much from the new directive of the Commission, of course. Madam Defender of Rights, I would just like to add a comment compared to the different questions that for the platform, the anti-discriminatory platform. We created us at the demand of the President of the Republic and the Minister, Elisabeth Moreno, and we want to remain independent, as you imagine. It is good to remind this, but just a word on the submitted orientation. It's one of my great preoccupations. I'm happy you underlined it because the teams know well about it. And of course, there are questions asked in terms of access to right to education and in terms of discrimination as well. Concerning controls on fraud with social minimas, frauds on algorithms. We are looking to have information to see what exists in the algorithm that helps to control the fraud. And we have a few suspicions that we can control more women alone, living alone. And we would like to work on this, and we are very worried about this because, yes, non-recourse is because, or non-use is because people haven't succeeded or were banned from the list, and you understand well that the worries of those who are far from these rights need help. So, of course, it's only one visible part of the iceberg in questions of discrimination. One part worries me, and those are the ones that are farthest away from law, and this is why we need to be efficient to fight against discrimination for those who are the most remote. This is a true objective of our institutions, one of the challenges and not one of the easiest. I'm sorry, I am told that we can take only a very small question, a tiny question. Thank you very much. Thank you, Anthony D'Albert, Secretary General of PRIFO, an association of lobbying to defend overseas territories. What about the private sector in actions on discrimination? Today, we haven't heard about the societal responsibility, social responsibility. We could mobilize funds to finance associations who are engaging against this discrimination. On the other hand, wouldn't be necessary for the court to systematically, for lawyers to ask for compensation to feed the fund, because these financing are public funds that come from the different ministries that help to associations defend victims. Thank you very much for this last question. With a great pleasure. I will, unless one of our speakers would like to answer, but I think I will answer to this question because I think there's a very important element here, and this is perfect timing to link the questions to the question of trust, non-recourse to law, and the finance question. So for me, one of the answers to this is to have more collaboration with different entities, and namely public-private sector. I'm thinking about this to a series of great law firms in order to have their RSE quota, CSR quota, for pro bono cases, namely, and these are one of the possibilities. There are others, of course, but indeed, thanks to this notion of social responsibility of companies that is not well known yet, there is a series of possibilities that exist. And I don't know what about the system in France, but in Belgium, at least, we could not ask for compensation, but maybe the fines maybe could feed a specific fund. I think that would be complicated, but collaborations, whether financial ones or based on expertise, as Patrick Patrick spoke about the fact that we have for structural discriminations and systematic discriminations that are the purpose of the big challenge of the 21st century. We have a series of research documenting it very well, but how can we make sure that this research, scientific research documenting it, is accepted by the jurisdictions? Can they make change the proof? And the Court of European Human Rights does this, works on control, on based bias controls. And the purpose is, what is the European Court going to do with this data? Patrick. To answer to the question about tackling big actors, whether private or public, sometimes we're confronted to a difficulty, a very practical one. This is what happens on the ground. The number of lawyers specialized in discrimination right and in different sectors, whether employment, services, legal system. When you want to attack a big actor, regularly the firm or the lawyer says, I cannot defend this case because I already have defended the opponent. And this is why it's difficult to find the lawyers, since the important actors have regular recourse in all other types of litigations. And the ontology is such as if a firm, maybe just a firm, cannot take a case against someone it has defended before. Yeah. So that happens for public authorities. I'm thinking of SNCB for trains, or the equivalent of the RATP in France, and private actors. And we are confronted to these practical difficulties, these types of issues. Thank you. Thank you very much. I believe now we have to take a little break. We will have to close this roundtable, and I want to thank all of the speakers. It was a pleasure and an honor to moderate this roundtable. A great round of applause for our speakers. And I'm told that we will resume at 4:30. We're having a little coffee break upstairs now. Thank you.
is not as expert as it should be, so it's always best.
Okay, just it's 2:30 okay, and I think that okay.
I never know about the questions.
So hello everyone, welcome back to the conference. This is the second session. I hope you all had a nice break here and in front of your computer screens. This second session, my name is Tamás Kadar and I'm one of the co-directors of Equinet, as it is stated also in the agenda, so you might have guessed. I see some happy faces. Some of them are very soulagés, those who already gave their presentation in the previous session in front of me, but others as well, so I hope and trust that the first session was interesting. But this one is also going to be very interesting. I have three excellent speakers with me, and our topic is going to be other skills mobilized by equality bodies linked to legal actors in the fight against discrimination and the promotion of equality. Now, this is difficult because I think we are all four lawyers, and you know, why would we talk about anything else than law, right? But we felt with the Défenseur des Droits colleagues that it is very important to talk about other powers and other tools that equality bodies can use as well, because, and I think we saw that in the first session where our colleagues, shame on them, they did not really stick to just court and what they do in front of the courts, but they in fact went into some of our topics as well, which I think really demonstrates that you cannot just do legal work in isolation. It is impossible. You have to use it in combination, it was mentioned, with other powers, not the least because it's impossible to effectively litigate if done in isolation. We can think of how do you litigate if you don't have cases. We heard about underreporting. We heard about the importance of developing anti-discrimination law. Litigation is one way to do that, but there are many other ways as well. Societal change can also come, and that can be thanks to equality bodies. Publicity about cases is also important. And we also heard that many cases are also settling. So it's not always that you go through with a court case and you use your litigation powers, and that's the only way that you can achieve change. So we heard from the previous session that equality bodies are, of course, mentioned in the equal treatment directives. The first time they were introduced in EU legislation was in 2000 with the Race Equality Directive, and then they were subsequently introduced in gender equality acquis of the EU as well. But what we see in the directives are really just minimum standards. So it says only that equality bodies have to have the function of providing independent assistance, doing surveys independently, making recommendations independently, but this is more or less where it stops. And we found it, as Equinet, the European Network of Equality Bodies, we found it of utmost importance that we define a little bit better what do we mean by equality bodies, what these equality bodies should look like. So we have been asking for this, and not just we, also civil society. And I think that we are really grateful to the Commission colleagues, because the European Commission was quite receptive to this, these arguments and these requests. And in 2018, it's going to be soon 4 years ago, they published a recommendation, which is a non-legally binding instrument, but still a legal act of the Union, on standards for equality bodies. And now they are working on legally binding standards on foot of a report that was released on the application of the Race Equality Directive and the Employment Directive, which was published last year, accompanied by a staff working document focusing on equality bodies and really identifying, I think, that the recommendation was an important step, but it did not in itself lead to equality bodies all having the sufficient levels of independence, resources, powers, and so on. But the good thing is that we have here with us Claire Hasenfratz from the European Commission, DG Justice, who is much better placed to speak about this upcoming initiative very briefly, focusing on what it's going to give to equality bodies, especially in terms of powers. So I'll give you the floor, Claire.
Thank you very much, Tamas. I think you've introduced very well the different steps of our EU equality law, and now we are indeed working since last year on a new legislative initiative on binding standards for equality bodies, which would be a minimum requirement to make them strong or stronger. And I will just give you a few elements on the timeline. So we've been working since last year, and we published a roadmap in July 2021, and there was also a public consultation. We did a study, we interviewed all equality bodies through the study, we had workshops and a participative conference, so we have really consulted largely all stakeholders, and now we are very much in the process of drafting the legislation. So nothing is definitive yet, and so everything I will say has not yet been approved by the Commission. So I'm just talking about what we have discussed during the consultation, what the stakeholders have given us as a message, and what we are thinking about. I cannot, of course, guarantee that this will be in the proposal that we aim to adopt in September this year. So that being said, we are here to talk about litigation powers and things that are near to litigation powers, but I just want to make a first point saying that our proposal will address also resources and independence, because these have been identified as key challenges for a lot of equality bodies. And so the proposal will address that, and in particular, the sufficiency of resources so that equality bodies can really play a meaningful role and fulfill all their tasks and mission. And this has already been discussed in the first panel as a major challenge. So this will be addressed, but here today we are here to speak more about litigation powers and what is around that and the role of equality bodies in front of or around courts. So we had a dedicated workshop organized on powers of equality bodies, and litigation powers together with investigative powers came at the very top of what equality bodies and other stakeholders told us was really important for equality bodies to be able to make a difference. For us at the Commission, we are very careful about the different legal traditions of member states. And a key message that we have received is that stakeholders, equality bodies, don't want a one-fits-all model of equality body, because they have all developed their own way of working. And you've seen that in the first panel, that they all do it slightly in a different way. So our objective is not to say all equality bodies should be like that, but is to be sure that they all have the minimum powers to be able to effectively help victims access to justice. And so thinking about that, we are thinking about the different powers that could help, meaning that we would like equality bodies to have them, but they would be able to choose which one they use and in which proportion, depending also on the legal tradition of the member states. And in these powers, we are thinking, of course, about litigation powers, being able to act in court on behalf or in support of one or several victims, and also, and it was mentioned by Patrick several times, being able to litigate in their own name, even in the absence of a victim, because this was also said many times to us, that this is very important, that sometimes there is no victim or no victims really can afford to go to justice, or there are other problems that stop they from going to court. So the equality body should be able to do it. So this is what we are thinking about litigation powers. But then there is also the possibility to make statement, oral or written, in front of the court. We have spoken about amicus curiae, and this we think is essential, that in any case, equality body should be able to make statement to the court. And then there are also other ways that victims can access justice, like, for example, conciliation and mediation, and some equality bodies do that very well. And it's sometimes the system that can be more effective or maybe less costly or quicker than going to court. And whenever there is no strategic reason to go to court to make an interpretation of the law that we need, sometimes mediation or conciliation can be also a good way. So this we are also thinking that it would be good for equality bodies to have mediation and conciliation in the respect of national procedures, because some member states are more developed in mediation and conciliation than others. But there are some procedures about mediation and conciliation in all member states now, thanks to other EU legislation. So this is what we are thinking about litigation powers and everything that is around. Yes.
Thank you so much, Claire. I think this was really interesting, and of course, as Claire underlined, rest assured that what she managed to speak about, because of the lack of time, was only a small part of what's going to be in the legislation. So independence resources you mentioned, but also there are going to be provisions about other important aspects, such as accessibility, coordination between different equality bodies and other actors, and so on. And I think it's really important also that you underlined conciliation or mediation or equality bodies working on their own cases and making their own recommendations or decisions, because I think this is also a way that can lead to better access to justice for victims. And of course it does have a direct effect on the court system as well, because it is alleviating the caseload that appears in front of the courts. And I think it's also very important to see that courts are sometimes acting a little bit as an ivory tower, but they are still part of society. And if there are some major societal changes which equality bodies are trying to achieve to make societies more equal, then it will obviously also have an effect on the court system and what we see as results of litigation. And equality bodies also, I think, are well placed to try to achieve these massive changes with their promotional powers. Also with litigation, of course, we see that some of them can really bring up new areas of work, such as artificial intelligence or ethnic profiling, or not just new, but also sometimes areas and issues that are contentious in the country context. It can be religious discrimination, ethnic profiling, artificial intelligence, or LGBTIQ issues. And I think this is a good point to move on to our first round of questions, which I will first ask to Romanica Jordache. And I suppose the first issue that we could talk about is very much linked to what we were listening to in the first session, but maybe from a slightly different angle, and looking at what are other ways in which equality bodies can be engaged. How can they support litigation when it's done by NGOs, for instance, or what are the different other ways that they can appear? And you have, I think, some really interesting experiences to share.
Cases. Premièrement, je voudrais vous remercier pour l'invitation.
First of all, I want to thank you for this invitation. Then I'm going to talk in English, which will be better.
So, what can a national equality body do in engaging in support of the victims? And my response is coming not only from my experience as a researcher based in Romania, but also based on a thematic report that the Equality Law Network of the European Commission produced and released earlier in February this year, which is called Effectively Enforcing the Right to Non-Discrimination. And together with my colleague co-authoring the report, we had this amazing opportunity of looking at the practices and the legislation in all the member states, plus the EFTA countries, and we realized that even if the equality directives are in a way perceived as a minimum standard, in every single country that we analyzed, there is something additional. There is an extra mile. There is, maybe in terms of supporting the victims, maybe in terms of the burden of proof, maybe in terms of engaging with the stakeholders. There are elements that build on the directives and show the commitment of the national actors in taking discrimination and anti-discrimination work seriously. And one of these ways goes back to what the national equality body can do in court in supporting the victims. Isabel briefly mentioned the different positions that a national equality body can have before the Court of Justice of the European Union or the European Court of Human Rights. With our report, we actually found several other positions, and based on our Romanian experience, I will mention two more roles in which the national equality body can seriously engage in educating the judiciary, in supporting the victim, and in changing the legislation. So I will start with my favorite case, and it's a case that I've been working on together with the Romanian National Equality Body. We ended before the Grand Chamber of the Court of Justice of the European Union. It is called Coman Hamilton and Accept versus the immigration service, the Romanian immigration services, and deals with the refusal to recognize same-sex marriage in the context of exercising freedom of circulation in the EU. So same-sex couple, Romanian citizen and third country national, American, who want to come back to Romania after they got married in Belgium. Now, what does this have to do with discrimination? Obviously, you take the case to court, and in the very favorable case of the Romanian legislation, all cases that are grounded on the anti-discrimination law are communicated with the National Equality Body, which has a weird standing. It's not a third party, it's not an intervenient, but it is recognized as an expert institution. So the judges have this opportunity of hearing the message that comes from the experts dealing with discrimination cases in every single day. And this was 2018, and I have to give you a bit of the context. That was a time when in Romania there was, the campaign was taking place for the proposal to amend the Constitution. So it was the time of the referendum when people in the Constitutional Court were supposed to decide if the definition of family from the Romanian Constitution should be restricted in order to include only the marriage between a man and a woman, or be kept the way it is right now, which is much more open and can be interpreted in a more progressive way. So our decision was to take the case to court and then seize the Constitutional Court, because we felt the need of bringing a human face to a very hateful discussion and a very theoretical discussion, which was taking place in an illiberal register, but had nothing to do with the victims and with the beneficiaries that we were working with. Obviously, the national equality body stepped in. By law, they had to. And this is where the magic happens. Because when you have an independent institution, depoliticized, ideally, they can make the equality arguments. They can join you as the lawyer working with the beneficiaries and explain to the constitutional judges the value of equality as embedded in the Constitution and in the international standards that Romania ratified, but also can help, they effectively helped us in encouraging the Constitutional Court to send the referral to the Court of Justice of the European Union. That was the first time the Romanian Constitutional Court used a referral. They didn't even know how to do it or if they had the power to do it. There was an internal discussion and a very interesting dissent in that case. So having the national equality body on our side meant the constitutional judges understood the European dimension of our arguments, decided to get rid of a very hot potato by sending it to Luxembourg. But also they got educated on what are the challenges of same-sex couples in Romania. Now, the long story short, the decision from the Court of Justice was a brilliant one because it spoke about the need of effective protection that forced the Romanian constitution, which is quite conservative also, to come up with a very courageous decision. Don't worry, there was no change in the legislation, and now we have the same case in Strasbourg. But it is a process, and what was very important was that in this fight, which was very polarized, with conservative groups on one side and progressive groups on the other, discussing the referendum as something useless and immoral and deciding on restricting the rights of a part of the population, the national equality body stepped in and had this reasoned and very profound argumentation that mattered a lot. There are also other ways in which the national equality bodies can engage with the Luxembourg court. One is also Romanian example as defendants, so not only as plaintiffs or as third parties intervenants, but that is also a possibility. We did it, the case is called Accept versus the Romanian National Equality Body. We were unhappy with the decision issued by the National Equality Body in a discrimination case, and that led to analyzing what is an effective remedy for all of us. And then there is the case that Patrick mentioned, with the national equality bodies being involved in supporting the member states to issue strong opinions in the key cases. In the common case, on the other side, we had the Polish and Hungarian and Latvian governmental agents. It felt terribly lonely to speak about the need of protecting fundamental freedoms and not get support from the, at least from the member states that recognized the gay marriage. So this is an important role which I think needs to be further used. In Strasbourg, there is a bit of the difference. It was already mentioned, so for the sake of being brief, the possibility of intervening as amicus curiae was already mentioned. What I would mention from the Romanian experience, which is once again a positive one, is what happens after you have a good decision, after the Strasbourg court issues a judgment that is like, I will give the example of the case that we worked on, MC and AC versus Romania, which is a hate crime case with homophobic attack. Following that decision, as a part of the implementation, a working group was established. We have a joke, you do a working group only when you want to make sure that the problem is not solved. The presence of the national equality body in that group, together with the police, with the prosecutor general, with the Ministry of Justice, brought additional elements in the discussion and in a way balanced calmed down all parties, NGOs and very upset lawyers, as well as very upset authorities. So that would be in Strasbourg. I would also mention the role some of the NEBs have in supporting procedures with the different UN committees. And in the report, we covered the Norwegian example because I think they're the ones who managed to tick almost all boxes. So CEDAW, CERD, CRPD, you name it, they were there supporting victims. But that takes me back one step to looking at the facts. I happen to work with beneficiaries, with the people who are the victims of discrimination and who often refuse to initiate the procedures out of fear of further victimization, but also out of fear of costs. And this is something that was touched in the previous session. There are studies, the Fundamental Rights Agency did the big surveys on ethnic minorities, on Roma, on the LGBT community. The most recent study is from 2019. If we don't find a way to secure funding to support victims, then we're not going to have cases. And here there are some models based on the comparative work that we did in preparing the report. I will just name my favorites, and you'll have to stay with me and then shut my mic. My all-time favorite is the case of the Italian UNAR, and that comes in a context of not having a very rich jurisprudence on discrimination. So their way in was to create a solidarity fund, which is supporting lawyers in providing not much. We speak about €600 for each procedural stage, but this is money that is given to the lawyers. In a way, I understand that UNIA, with its negotiating power, is doing a similar role. So they're supporting the lawyers in order to take the cases, and then this money comes back once the cases are won and new cases can be taken. There are other models as well. Patrick mentioned UNIA and its work, so I'm not going to put myself to shame by just briefly mentioning it. I would also mention the Austrian Litigation Association, which is an association of NGOs working against discrimination, which has preferential legal standing by law and which is funded by the Austrian authorities. So there are ways of helping the helpers, of creating the environment that facilitates the legal action in a way that is helpful for the beneficiaries after all.
Thank you very much, Romanica. I think what you mentioned is really opening up some other interesting ways to think about how equality bodies can engage. And honestly, some of the examples are a little bit disheartening if we think about good European level judgments and then nothing happening at the national level. But that's another story for another day, I suppose. Tena Semanovich File, the Ombudswoman of Croatia. Do you also have something to add on these? How does your institution, for instance, support the helpers? Just if you have some brief comments on that.
Of course I do. But before I start, I do want to thank the Défenseur des Droits, Equinet, and the French Presidency for organizing this discussion in such a crucial time. And it is exciting, and I want to say this on the stage because, you know, and I have to also say I'm if I understand correctly, the only representative of an equality body on the stage right now. And having worked in one for some 15 years, I can tell you, also through Equinet, but also in the national work, we have been advocating for standards for equality bodies for so long. And once you work in an institution like this, you understand really, really why. And we've been dreaming about legally binding standards. So yes, this is so incredibly exciting. And I do hope that this conversation we're having right now will enrich the draft legislation that we're hoping for. So yes, so from the perspective of equality bodies, and I do also have to say that while EU level litigation is incredibly important, there's also national level litigation, which many of us are involved with, and that's where our national anti-discrimination legislation lives or dies. And what we have seen is that supporting NGOs, beneficiaries, but also NGOs when they start strategic litigation cases has been incredibly important. So what we do is we can join as interveners in civil court proceedings, not as amicus curiae, so we're not friends of the court, we join on behalf of the person claiming discrimination. And how that works is, of course, we're giving legal arguments to the court in support of the arguments of the person claiming they have been discriminated against. But also it serves, and that's from the perspective of the court and the law and rule of law. But from the perspective of our relationship with NGOs, I also have to say that this shows a certain support which goes beyond. And it's a bridge building exercise as well. And it's a relationship building exercise. So becoming an intervener in these cases which were started as amicus curiae cases by civil society organizations has also been incredibly important, not only for victims of discrimination, not only for the rule of law in those cases, but also for our relationship with the organizations. And I won't go further because I know there's many more topics to cover.
Indeed, thank you very much, Tena. And I think that building bridges is really what equality bodies are about, being a bridge already between civil society and governments in many ways. And I think what you mentioned and what we are discussing here also shows that how equality bodies can contribute to this equality of arms that was also mentioned very much in the previous session. So moving on finally now to other powers as well and other ways of contributing and influencing. What about equality bodies doing promotional work? And when I say promotional work, I mean it in the broadest possible sense. Trainings to judges and legal professionals, campaigns, awareness raising with which they can change society and perceptions, research, for instance. And this time I would like to ask you, Tena, to start.
I love that. I love the cases, our own cases, in which we issue recommendations. So we do not issue legally binding decisions, and we cannot decide on sanctions. But even the recommendations and warnings and opinions can work in cases. We also are involved in strategic litigation. But what I personally really love is the preventive work that we do. Because in all the cases, you have a post-festum reaction when discrimination has already occurred. But I do think it is worth investing our time in working on legislation, before it is enacted, in campaigning, in research, and in training. So we've done a lot of campaigning, initially very broad when the legislation first entered into force in 2009, and then specializing through time, looking at specific areas of law or specific groups that we were targeting. In terms of research, one thing that we found was really useful is while we sometimes do specific pieces of research, like hate speech online amongst young people and things like that, which is connected to our non-discrimination mandate, we also do a same bit of research that we repeat using the same methodology over time. So repeating it every 5 years, where we look at a couple of things. We look at the levels of stereotypes and prejudices. We also look at the awareness of anti-discrimination legislation, the knowledge and awareness about our institution, which also shows our accessibility to the public and to various communities. And we also look at perceptions of discrimination and self-perceptions of discrimination. So through time, you can really see the trends, and that makes sense. So some specific pieces of research, but also something that we repeat over and over again. But training is something that I always like to go back to, not just because I love to talk and train, and some of my staff does as well, but also because I think it's crucially important. When we're speaking about legal proceedings, we have trained judges, we have trained attorneys, we have trained public prosecutors, and we have trained police. Why I'm mentioning police is because in our legal system, they start misdemeanor proceedings based on the Anti-Discrimination Act. But also, you know, after training judges over and over again, we realized that we should not train only judges, because if the attorneys are not trained, and if they don't know how to put the case together well, the judges cannot really do what they need to do in civil court cases. So we trained attorneys in cooperation with the Legal Academy and so on. We've also trained civil servants, media representatives, NGOs, trade union representatives, employers, and so on. And we've also specifically trained judges on the Charter of Fundamental Rights with some specific trainings on the anti-discrimination component of the Charter. Now, this may be a bit of advice for those who are planning to train judges. It was so difficult to find the right model. When we initially started training judges, there was a lot of resistance. They were saying, oh, you're not a judge, you cannot train us. And then we brought judges from outside. So we brought Austrian judges, and they said, no, they're from a different legal system. They don't know how things work in our country. And then after a while, we figured out the right model. And for us, at least, the right model is involving a high-level judge, a Supreme Court judge. So together, coupled with an expert from our institution. So we're experts on non-discrimination, and Supreme Court judges are there because judges respect Supreme Court judges from the national jurisdiction, and that works. So that's just a little piece of advice. So I'll stop there. I can talk more, but I know time is running out.
Thank you, Tana. I think this is I hope everyone took note. This was our, 1 minute bit of extra practical advice from Croatia, but I think it is really interesting. Just to ask back, it's a little bit of a rhetorical question because I hope the answer is obvious, but the research that you mentioned that you are doing, is that used in the courts? Are you using them? Are they using them? Are attorneys and others using them?
Use it in courts, but we also use it in strategic documents. So it's also used by the government in strategic documents, and it's also used by various other actors when they look at, it's used by media a lot. That's also important because we also work together with the media. When you do awareness raising campaigns, what we found out is that no matter how much money you have, and we usually do it from EU projects, you never have enough money to do a good campaign, because it's always very short, the minutes are expensive, and so on. But using the media as friends to spread the right positive narratives, to spread the right message, and to do it consistently, also using our research and sending our research to our friends, journalists and friends in the media, that works. And especially if you do it in a strategic way, so it's continuous, it's not a short blitz campaign, but you work at it over time. So yes, we use our research, courts use our research, and other people use our research as well. And sometimes it's about getting your research out there to the right people, and I would always say, give it to the media.
Great, thank you very much. And I think it also just shows how this is a big ecosystem that you have to think of, not just relationship between judges and courts and equality bodies, but thinking of prosecutors, attorneys, media, researchers, everyone. Please, I was going to give you the floor anyway.
Oh, okay, because the Romanian National Equality Body, and somehow it feels unfair because the president of the National Equality Body stands there and now I talk about their work. But they managed to do this annual survey of perceptions and attitudes of the population and experiences of discrimination. And Csaba will correct me if I'm wrong, but I think they did it in the last 20 years, almost every single year. Like they prioritized and found ways of doing it. And this is giving us as lawyers, as advocates for equality, an amazing picture, an amazing tool of understanding the evolution in our society, of not burning out and giving up our work as well, but also of adapting, so it makes us more strategic. It helps in courts, and it helps in prioritizing the limited resources that we have in order to do strategic litigation. Another interesting model of using the research is the one done by the Bulgarian Commission on the Protection Against Discrimination, because they're based on the numerous complaints that they received on accessibility issues. They decided to narrow it down and focus on this issue. So they for like 2018, 2019, they had a campaign which entailed research, which entailed awareness raising, but also ex officio cases that they initiated because this is a part of their mandate. So zooming in on a particular theme and then using all the powers that the National Equality Body had on that proved to be a good strategy. And on the trainings, yes, have your judges with you. That's one solution. The Romanian solution, we don't have the progressive judges, or we were unable to find them. But speaking from the position of the researcher, having done numerous trainings for judges, lawyers, policemen, you name it, the moment we did the same trainings with the members of the National Equality Body, even if oftentimes we had different interpretations of the law and we had respectful different positions, the discussion between us proved to be useful for the participants, whether they were prosecutors or judges or lawyers, because they recognized the value of the debate, the value of remaining committed to fundamental rights, even if we have different approaches. And there was the question about trust. How do you build trust in relations? Trust in institutions is not a dead end, it's a process. The moment we manage to have this type of dialogue and stay committed to the dialogue, even if at times we criticize each other, that's how trust is built, by continuously engaging.
Thank you, Romanica. I think that's very important, this trust element, and I guess this is another illustration of building bridges. Claire, I was going to ask you about your views or the Commission's plans on promotional powers and what we are discussing now.
Thank you, Tamas. And indeed, in what we are working on, there are several elements that that go over this promotional role. First, in the current disposition on equality bodies, they are called bodies for the promotion of equal treatment, but actually then in the disposition, in the provisions, there is not an explicit task of promotion. So our view is that this should be made more explicit, that they have a role to play in both promotion and prevention, as you said, Tena. So this is something that we would like to do, and then to give some details on what forms it can take, like trainings, capacity buildings, information, a campaign, also publishing their decisions or recommendations. And then there is a whole part also on collaboration, because in the gender equality directives that are more recent than the racial equality directive, collaboration has been added as a task, but it's very narrow. It's only with the European Institute for Gender Equality. So we would like to enhance this obligation of collaboration to all public and private actors. And you mentioned them. It can be judges, attorneys, law enforcement, but also, of course, NGOs who represent the victims, and the media. That is a very good point. And then we have another part on, well, that is linked, of course, on awareness raising and accessibility. We have provisions on that because indeed there are research that proves that the people who are, some groups at risk of discrimination are actually the ones who know the less about equality bodies. Not all groups of at risk of discrimination, but some of them. So this is very important to raise awareness on people's rights and on the existence of equality bodies, and to do that in a way that it targets the groups in questions. Like, for example, for young people, it could be over social media. But then some other groups at risk of discrimination don't have access to social media or any IT tools. So campaigns should take very different forms to be sure to access everybody, to give access to everybody. And then finally, on research, we have held a dedicated workshop on data collection because we were wondering on which role equality bodies should take in the collection of equality data. And the result of this workshop was that mainly stakeholders said that there shouldn't be an obligation on equality bodies to collect equality data, that it's not their main role. They should still be able to do it, but it's not their main role. And what was highlighted is that the possibility to access equality data that is already collected by other actors was an interesting one. So we are thinking more along these lines, with keeping, of course, the task of making surveys that is already in the current provisions. So this will still be an ability of equality body, and of course equality bodies who are very involved in research should continue, but there is also this way of accessing data collected by others, and maybe even making recommendation to these other actors that can be the statistical offices or the labor inspectorates, making recommendation on which data they should collect, and have a dialogue with them so that equality body can use this data afterwards, of course, in front of the court or in their reports.
Thank you very much, Claire. I think this whole plethora of other things really shows that these broadly understood promotional powers are not a nice to do, but they are actually absolutely necessary for equality bodies to be able to do their job, which, at the end, ultimately is a question of how effectively equality legislation is implemented. But just rebounding on what you mentioned about equality bodies collecting data, I think this really nicely leads to our last round, so bear with us for a few more minutes, about how equality bodies can also play a very important role collecting data, including about court cases. And I think Tena will have a really interesting example on this.
Stop myself from sharing a little bit more on some other things. Building trust is one of my favorite things to discuss, and I'll be just really quick. It took us years and years of strategic planning on how to do outreach well, and years to really raise the number of Roma complaints through various ways. So we did 7 different things in parallel, but through years we were able to do it. It's a conscious effort. Cooperation and collaboration, I think we're one of the few countries where the Anti-Discrimination Act actually obliges us to cooperate with NGOs. And it says that we must do so in relation to our annual report. And we do an annual report not on our work, but on the situation of equality in the country, which is really difficult to do because you need to reflect on all the major events of the year, even the contentious ones. There is no skipping over anything. So collaborating with NGOs is really important for that one. We would be doing it anyway, but it's in the legislation. When it comes to data collection, yes, the perspective of many equality bodies is we just cannot do everything. And I know the Commission would like us to, but we just cannot do everything. And it's good to have publicly financed bodies do data collection well, but I see a role in equality bodies talking to these institutions in how to collect equality data. But one thing I do think is incredibly important is equality bodies having access to data. Sometimes it works well if you are also, let's say, an ombuds institution which has access to unlimited access to data. We, for instance, do so. Any sort of secret, classified, surveillance, whatever data we can access it comes handy. For instance, banks in banking cases say, oh, banking's secret. We say there is no secret to us. That's really, really useful. So think about putting that in our legislation as well. And finally, something that hasn't been mentioned, expert opinions. It's great when in your legislation you have an obligation for experts that you consult, let's say medical experts. Let's say you have a case which is about discrimination in healthcare. We are mostly lawyers. Yes, we work in multidisciplinary teams, but I cannot have a specialist on every single, health condition. And then we write to the university medical experts and to professors of whatever area of medicine it is to ask them for their opinion. Was there discrimination in a particular case? Cannot be really found without such expertise. So I'll stop there. Monitoring court cases. Yes, so initially there was an obligation in our legislation for courts to send statistical data on court cases to the Ministry of Justice. It brings it all together and it sends us the statistics. And after a while, we saw, they weren't collecting the statistics well, so we worked with them to get better data collection on the court cases. But we also saw we really could not see what was happening because you don't see whether they're reversing the burden of proof without reading the judgments. And so after some time and some negotiating, we got the courts to start sending us all the court cases. Now, in some countries, all judgments are open to the public and published. In my country, they're not. Only those of the Constitutional Court, the Supreme Court, and so on. If you're an attorney or a judge, you might have access. Everybody else doesn't. Now we get all the court cases for some time now, and we do an annual analysis of all discrimination court cases issued by various types of courts. So civil courts, misdemeanor courts, criminal courts, and administrative courts. We analyze them, and we publish the analysis as a part of our annual report, because we think it's our role to show how the anti-discrimination legislation lives in our courts. We also did a publication of our own, summarizing what we found over a period of time. And, not all the judges were always happy about our analysis of what the judges and the courts were doing. But eventually, I think everybody came to appreciate that we were doing such an analysis. So that's a brief story about our monitoring of court cases.
Thank you so much, Tena. And as you saw, we received a letter. And that tells us that we will have to slowly wrap up. But I wouldn't want to wrap up without giving the floor both to Romanica and Claire for their thoughts on this topic.
Okay, as we are getting evicted, I'll just build on Tina's remarks and make a point of something that I saw as inspirational in the comparative work that we did with the report, and that is being strategic. National equality bodies are often under-resourced, but also under the heat of all stakeholders asking them to do multiple things at the same time, with the expectations of the general public of changing the societies overnight. Where we saw a difference, and here I also, but once again, I feel like a fraud because the examples I gave are our host, the Défenseur des Droits, and UNIA. These are the countries where the national equality bodies do the self-reflection work periodically, either by law, because there is a legal obligation to do a self-assessment, to have this kind of understanding of what is happening with our work, with our impact, or as a choice that is done at the level of the institution, and that shows leadership. So if I would have to advocate for one element to be included in the future directives, it is that self-reflection, that element of monitoring your own work, not only in terms of doing the usual activity report or the state of equality in the nation report, but also taking the time of having either an internal assessment, which is not that expensive, or an external assessment that leads to strategic planning. Like having a strategic plan actually gives you the chance of being strategic.
Thank you so much, Romanica. And I think that these are, of course, linked. You need the information to be able to reflect on it and to be strategic. And of course, you also need the leadership and the will, because it's very easy to make it a tick box exercise, with which I give an easy way out to Claire, who can maybe close.
Yeah, so just to close and react on what you just said. So we are thinking of having, in terms of report, both an obligation for the annual report that most equality body anyway already do, and then another obligation for strategic planning, for really for the equality body to really make an assessment and think of what are their priority, what will be their prospective activities, and where they put their energy and resources, and this could be fed by another thing that we are thinking about, is to ask equality bodies to have a report on the state of discrimination, but not every year, because this would be too much, but something like every 4 years or something like that. And this report would be fed both by the data that equality body collect on their own activities, and then the research that they do, if they do some, and then also data that they can access that are collected by others.
Thank you so much, Claire, Tena, and Romanica. If I wanted to summarize, it's not my job to summarize, but if I wanted to, I think there is a lot of potential, a lot of expectations, a lot of good practices out there, so it's a really exciting period. I agree with that. And with that, I think we'll open the floor for maybe one round of Q&A. Is that okay still? Yeah. So if you have any questions, then this is the time. Monsieur Charlier.
Je vous remercie, monsieur.
Thank you very much, Mr. Kadar. I wanted to ask a question when we talked about the activities to promote, to train judges, magistrates, etc. If an organism to promote equality wanted to have a serious program for magistrates, is there not a risk at some point if in the future we are led to be in front of a judge the opponents could imagine that the independence of the judge is affected because there was this training organized. Is this something we need to pay attention to?
Questions, or should we ask the panelists to respond to this? The risk of potential conflict of interest, essentially, if training is given to judges. There is one more question there. Yes, Calliope?
It is actually something related to what Patrick already said. It is relevant to the independence of the courts. And it is the case also in Greece, where we can have training programs with the judges, but only with the school of judges. After that, it is very difficult to reach them. And in a sense, I realize the reasons and I respect them. Or at least I think that it is a conversation that we have to do and to be very cautious when we do these kind of things, because yes, it is evident that in the future we can be in the court or have a relevant case, and this is something very delicate.
Thank you. So it's one set of similar questions. Who would like to start responding? I'm looking at you, Tena. Just wait for the mic.
I do see the point. However, unless you teach the judges the equality body is always right, but you teach them about anti-discrimination law correctly and according to the European standards, I actually don't see where the real danger is. I think sometimes we also run the risk of speaking about our own independence and imagining ourselves in an ivory tower and speaking about the independence of judges and thinking about them in an ivory tower. So what's worse, having judges who have not been trained on anti-discrimination law at all, judging in cases of anti-discrimination, or having an equality body train the judges if there's nobody else in the country able to do it so well? To me, it's quite clear. And yes, don't trade them and say, you know, we're always right, because that's not the point. And then there's no real conflict.
Claire?
Yes. I may just add, we are also thinking about a provision in the future legislation saying that the structure of equality bodies should allow them to exercise the different powers independently. And this provision is originally to a reflection on equality bodies that have both decision-making powers, and so they should be impartial in that exercise. And then on the other end, they still need to support victim and be on their side. And so in this situation, it's good to have like an iron wall between the two different powers, and this not being done by the same people. And I think this can apply here too, like the service providing the training should not be the same that will be in court in front of the judges. So that the judges at least don't know the person because that person has been giving the training.
I'll finish because, and I'll disclose my list for Santa Claus, and that would be all civil servants and all judges and prosecutors when they have their initial training, as well as their continuous legal formation. They would take human rights, and in particular an anti-discrimination course. All civil servants, when hired, would have in their bibliography for the selection competitions, would have the anti-discrimination law and the significant cases in the country and the Strasbourg and Luxembourg court cases relevant for the country. I don't think education is a very biased tool of changing the world, but this is the only one we have. It would be unethical for the trainer to show up in court. And oftentimes when we have trainings in the judiciary, we ask ourselves if the cases that we are using were decided by them or their colleagues. And so even the case studies that we choose are selected in a way that is respectful of the independence of the judges, but strong partnerships with the national institutions training the magistracy are needed, and ideally memorandums of understanding, like clarifying the boundaries. But this is needed. Otherwise, just waiting for the law schools to take anti-discrimination law classes, I don't see, maybe there are countries where this is happening. I don't see it happening that soon as we want. And you want the information to reach judges and prosecutors.
Yeah, I'm sure that's the case in some countries, but not in enough countries. Yeah, and I think that, in fact, just two comments from me. One of them is, I think that this argument of conflict of interest and undermining their independence is being used in quite a bad faith. That's one. And then the other thing is, I think we are really underestimating and undervaluing judges if we think that one short training or however long training is going to be able to undermine their independence. That's just from me to finish. And with that, it is my pleasure to thank very much our panelists, Romanica, Tena, and Claire. Thank you very much for your contributions. And it's my honor and pleasure to hand over to Madame Georges Beau-Langevin, who is Deputy Defender of Rights in charge of the fight against discrimination and the promotion of equality.
Mesdames et messieurs, chers amis.
Ladies and gentlemen, Defensor of Rights, dear members of the Equinet network, I want to thank you for having come today for this conference and in so many numbers. And I want to thank those who are listening to us remotely and who are still here with us. This afternoon was extremely interesting. We have heard two roundtables that were fascinating to speak about the difficulties and challenges met by my organisms and the different jurisdictions. So the first roundtable, hosted by Mr. Rorive, was speaking about the roles of national equality bodies before national and European courts. And you spoke about the experiences, as was said, amicus curiae, you in front of the jurisdiction, and the contributions on law and non-discrimination and its development. The second roundtable, hosted by Thomas Kadar, we talked about the other possibilities that our entities have, our bodies have, to mobilize in connection with legal actors in the fight against discrimination and the promotion of equality. We talked about training. These are very important notions when talking about our topics. What I have remembered is that the modalities of intervention of our counterparts in Sweden, in Ireland, in front of national and European courts show the importance of having powers that go beyond the minimal standard that are in effect today. We also all thought and saw that the access to justice is difficult for citizens, especially when victim of discrimination. We also said that even for our institutions, it is complicated to create relationships of trust to provide our expertise in non-discrimination law through observations in particular that we can formulate. We have also seen on the European level very few Equinet members have already been able to intervene before the Court of Justice of the EU. So we see that it is very little visible and complex. So I believe that we have margins to make progress and leads to explore. During the second roundtable, we saw other ways to collaborate with the legal world, and the Romanian example, the Croatian example, talked about education are leads to explore. On our side, for the human rights defender has signed numerous cooperation protocols with the appeal courts covering the French territory. I think 32 out of 36. So we now need to give life to these protocols, which in practice are not always as gratifying as expected. On the other hand, we also have seen that if our cooperation between the magistrates is satisfying, the litigation of discrimination remains residual. The number of decisions given, for example, here in France, in terms of the courts, is something that is symbolical. We have just a few interesting decisions in the courts for social matters, but otherwise there is really something to do for it to exist more. We have the feeling that we need these kinds of meetings, as that of today, happen regularly. We need to have a better partnership with the École nationale de la magistrature to offer training. And finally, I wanted to say that, nevertheless, recourses in front of the courts have developed because it is a European creation more than a French tradition, and we see well that we are able to make progress, but we still remain with a vision that is an individualistic one. Individual recourses, individual condemnations. So we see that the problem of discrimination is rather a collective problem, almost a systemic problem, but there are words that people dislike. We need to be able to use it at best, and maybe we need to change things to have collective recourse. And we have seen that the changes and the action groups do not provide the results we wish. We will have the occasion tomorrow to continue to do this work of reflection, and we will continue to work on transparency of salaries. This is also a very important topic. What I need to do now is to say that our institutions have a major role to play to make our European societies more egalitarian. And, of course, on equality between women and men in particular, we will see this tomorrow. We will need to have the means and adapted resources if we want to effectively change our societies. I'd like to thank all of the speakers. First of all, those who have traveled to talk to us. And I would like to thank them for the work on a daily basis that help victims and make sure that their rights are respected. And we might think that if they weren't there, they wouldn't have the strength to fight and to resist to injustice. I'd like to thank also the people who organized this meeting, and Nefali Yatropoulos, who steered this entire work with the support of Valérie Fontaine, who is here, and also trainees, Lily Haribo and Reda Gafouli, who worked very well. Thank you to the communication department and to Equinet for their support, their patience, their availability for the preparation of this afternoon and tomorrow, which we will be very numerous. A great thank you also to the interpreters, to the velo typing service for the difficult work you have accomplished today. And since we always speak better around a glass, a drink, I will invite you now to walk up the steps. You know the place well now. We will be able to meet, to have a discussion, but the cloakroom closes at 6 o'clock, so be mindful of this information. Thank you very much and good evening to all.